I wouldn't get.
Hello.
I knew you'd
How
be
nice
next.
was it to be able to?
What up, Robert? Reginald. Reginald.
Hmm. Well, that's interesting.
This is 2403403 LT Swan Creek versus Nicholas Petway Turner. Your appearances, please.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
Good morning, Your Honor. Nicholas Petway Turner, for the defendant.
Good morning. Today was the day and time scheduled for the adjourned hearing in this landlord-tenant matter. The parties have had the opportunity to speak. Ms. Ellison, how are we proceeding?
Your Honor, his application is still pending for assistance, so I think he's entitled to his final 14-day adjournment. So any date after that 14 days is what we're requesting.
Was that your understanding, sir?
Yes, ma'am.
Our next landlord-tenant date will actually be on July the 10th
Yes, ma'am.
at 9 a.m. We have first hearing scheduled on that date, but I will take you all right at 9 o'clock if you can get logged on time, okay?
Absolutely, Your Honor.
Yes, Your
Was there
Honor.
anything else, Ms. Ellison?
Not for this file. Thank you, Your Honor.
Thank you. Anything else, Mr. Petway?
No, Your Honor. Thank you.
Thank you. Have a good day.
Thank you.
You too.
She's probably handling.
And I see all three of them here. Mr. Nykel, Mr. DePietro, and Mr. Austin, have you had the opportunity to speak this morning?
No, we have not, Your Honor. In fact, I didn't even get my jacket on yet.
That's correct.
Would you like the opportunity to
Yes.
speak, or are you ready to proceed?
Yes and yes.
Always
Mary
willing
Ann
to
will get you
speak.
moved into a breakout room. And when you're ready, she'll let me know. I'll come right back out.
Thank you, Judge.
Thank you.
Thank you, Judge.
Just before you go, the court did receive from Mr. Nykel they start leaving. So Mr. Nykel, the court received your response last night at 3:51 PM. So I haven't had a chance to review it, but I'll take it up with the parties when you come back out.
I appreciate that, Your Honor. I apologize for the lateness of it.
No worries. Thank you, sir.
Okay, I did that with Dan. Remember one for me, I thought it was fun.
This is 2400518GZ. This is Papazian versus J&M Towing, Romulus Police Department, and Best Asphalt. May I have your appearances, please?
Edward J. Nykel, P 42017, on behalf of Paul Papazian, the petitioner.
James Austin on behalf of J&M Towing.
Good morning, Your Honor. Tom DePietro appearing on behalf of Best Asphalt.
Good morning. Today is the day and time scheduled for a hearing in this matter. The parties have had the opportunity to speak. Mr. Nykel, how are we proceeding this morning?
We're going to have to proceed with the hearing, Your Honor. We have not been able to reach a settlement.
Understood. Sir, do you have all necessary witnesses and documents with you?
Yes, I do.
Same question to you, Mr. Austin. Do you have all necessary documents and witnesses with you this morning?
I do, Your Honor.
Mr. DePietro, same question. Do you have all necessary documents and witnesses?
Yes, Your Honor.
Mr. Nykel, any opening statement?
Sure, Your Honor. I would like to state on behalf of the petitioner that this position of the petitioner and moving forward here is one, to show the court that the statute, should not be applicable to the facts that are presented to the court. That there was a lessor-lessee relationship between Best Asphalt and Paul Papazian, actually complete. Diesel Repair LLC was
It's not the asphalt. They're not, nothing to do with
the entity that came, that had 8 vehicles towed to the yard of Best Asphalt, that Mr. Papazian was had control of that LLC as a sole member of it. That he initially, actually, this was in 2020, and that it was actually January 10th, 2020 through November 9th, 2022. There was about $1,100 monthly lease payment for storage. There were several trailers that were also on the property that subsequently were removed at a later date, November of 2022. And so that changed the rental to $450 a month that was being paid by my client through various, through 2 different entities, Overhaulers Trucking LLC made an initial payment, and then subsequently American Crossdock made the later ones. There was 1 cash payment, and on the date in question, when January 4th, 2024, when the vehicles were apparently determined by the owner of the real property, Best Asphalt, that they were not properly being stored there. They were in fact properly being stored there because rent had been paid through January 9th, 2024. So the proofs will show payments that Mr. Papazian and Complete Diesel Repair were in good standing, and that those should never have been removed. It set forth a chain of events that ultimately led to my client paying the fees to be able to towing and storage fees to be able to get those 2 of those vehicles out of storage. paid about $9,820 for those two. Unfortunately, there were two other vehicles for which the Romulus Police Department failed to identify the VIN numbers and put forth a major delay in being able to do anything with those other two vehicles, which were two Kenworth tractors. And they remain at this point still in storage at J&M lot to our knowledge. And my client was never able to redeem those two due to the fact that there was an investigation proceeding that went to the commercial auto theft system, which is CATS, and it prohibited anything from being done until that investigation was concluded. That investigation didn't conclude until we were informed, my client was informed, May 9th, 2024, at which time J&M, my client was able to go to J&M's lot and had them contact Romulus Police Department. Romulus Police Department then informed J&M that, in fact, the titles were shown, that the VINs were located, and that the investigation was concluded. And so then ultimately a TR was issued. Unfortunately, because of the delay, to no fault of my client, he was never able to post any money to redeem. At the point in time when we were in last pretrial, informed that about over $24,000 in storage fees had accrued and towing, which was monumental for my client, not something he could handle, and he wasn't able to obtain a bond. So before the court, on a in a technical manner, is two vehicles that are part of this petition. The other two vehicles apparently are not part of this petition. It's the argument of my client that the statute doesn't apply because those vehicles, all vehicles, were properly stored by contractual agreement with Best Asphalt. And so my client asked for your honor to make that finding, and I would ask that on certainly an equitable claim that that there be a finding by the court that that the statute doesn't apply to any of these vehicles, and that the damages be awarded to my client that would reimburse him for the towing and storage that he did pay for the two vehicles that are subject to the petition, and that the court, if the court is not, and here's another factor that I'm going to bring up to the court, is that because it's been more than 30 days, that since the May 10th, I believe, when the TR was issued, my client did not redeem. That leaves those vehicles sort of, never to be adjudicated unless there's some civil action, I suppose. But because of the argument that that the statute is not applicable to this situation due to the landlord-tenant, so to speak, relationship, that asked the court to find that costs should and damages should be awarded to my client certainly by Best Asphalt and or the Romulus Police Department. because essentially Romulus dropped the ball as to those two vehicles that are not part of this petition. Fortunately, I was not able to get the parties to stipulate to add that, but there's where we are right now, Your Honor. Ask that the court find the statute inapplicable to this and award damages to make my client whole, including attorney fees due to the egregiousness of the situation that has put my client in financial straits. Thank you, Your Honor.
Mr. Austin.
Thank you, Your Honor. First off, I sent you a brief and I'm assuming that you read it. And that sets out pretty much our position. Just to touch on a couple of things that Ed hit. Number one is it's hard to make this not a petition under the statute, MCL 257-252A, because it's a petition on the abandonment of a vehicle. And the statute speaks specifically to this. If he wants to make it a contractual thing, he needs to file a different action, because there are exclusive remedies under this statute. MCL 257-252E4 says that the remedies contained in the abandoned vehicle statutes are the exclusive remedies. And those are found in 257-252F, which allows you to find that as far as my client's concerned, that they either properly remove the vehicle and their towing and storage charges were reasonable, or that they did something improper in removing the vehicle, or that the property owner improperly had those vehicles removed. Those are all set there under 257-252F3 for you to make that decision. And one of the things I think that you need to do before we get going is to make the determination that all we have here is petitions on the two vehicles that have been redeemed. No petition was filed on the two that are still on the property at J&M. And until those are filed, again, because they are exclusive remedies under the Act, they need to be brought pursuant to statute, and that hasn't happened. So I think we need to really narrow this down to there are two vehicles involved. It's a petition filed pursuant to MCL 257-252A6, and we have to go within those guidelines. And as I said in my brief, J&M followed those guidelines in the statute. They were contacted by Best Asphalt. Best Asphalt, as a private property owner, called them, said, we have 4 vehicles, 2 that are involved here on our property without our consent. We need them removed. J&M contacted the Romulus police pursuant to MCL 257-252-10 and 11, A10 and 11. Got the information to them. And at that point, J&M sits and waits for things to happen. They've done everything they need to under the contract, under the statute. And just to touch on the attorney fees issue, the only way that under a petition like this that attorney fees are allowed is if an action or a defense is frivolous. And that's in 257-252A. If perhaps you are going to expand and get into the other 2 vehicles, I would cite Auto Club versus Farmington Hills, 220 Michigan, MishApp 92, it's a 1996 case that holds that during a police hold, which this would have been if CAT is working on an investigation, the registered owner of the vehicle is liable for all storage fees during that time. So that's all I have, Your Honor.
Thank you. Mr. DePietro. You're muted, sir.
Thank you, Your Honor. I apologize. I would concur with Mr. Austin's jurisdictional statements. But first, this statute that we're operating under, and I can't cite it quite as well as Mr. Austin did, but it is this statute which gives this court the right to even hear us today. And it does not provide for extraordinary remedies other than to determine that the storage fees were reasonable and who among the owner, the tow yard, the police, and the petitioner should be responsible for all or a portion of those fees. And that's all this court can do. This court, the last time we were before you, and I read it, I confirmed it in the Register of Actions, this court has limited the hearing today to the two vehicles that were redeemed by Mr. Papazian on January 24th, 2024, and a determination with regard to the fees that are incurred to that date, which total $5,800. That's the amount of money he paid the yard to get the F-450 tow truck out of there and the Peterbilt. And those are the two vehicles that apply today. So the total claim today, whomever this court decides should be bear responsibility for it, is $5,800. The statute was invoked by Mr. Papazian. It is he who brought this case under this statute to you for decision. Nowhere in his petition, well, first of all, he didn't even name Best Asphalt in the petition. That's probably a moot point at this time, but his sudden focus on Best's liability is newly founded. Apparently, it didn't exist at the time he filed this petition. They weren't even named as an interested party. But secondly, and I think this is more important, Judge, the statute from a procedural standpoint, the statute is clear that the hearing we're about to conduct today shall be conducted by a magistrate in jurisdictions where there is a magistrate. Now, I'm sure all the parties are perfectly willing to have this court determine the case on its facts, but the statute also provides that the determination of a magistrate shall be appealable to the district judge. So I think we all have to agree on the record that we are waiving our right to appeal to you since and waiving the right to have the magistrate hear this matter and are stipulating that you may hear it and that we would not have an appeal right to you after the hearing is determined. The parameters of this case, the facts, the remedies are within the statute invoked by Papazian. I understand Mr. Nichols' desire to take this out and away from this statute because it does limit the remedies he's chosen to employ or to achieve. But it ain't up today. And neither are the two trucks that are still there. This case was bifurcated by Your Honor to apply only to the Peterbilt and the F-450. And in that regard, there's plenty of fault to go around in this case as to who should divvy up and pay a portion of that $5,800. Mr. Nichol has pointed out the failings of the Romulus PD. The statute allows for apportionment to the PD. I think he's arguing also that, but his arguments against J&M are going against those two trucks that aren't up to date. So I'm not even going to waste your time rebutting those. In any event, Judge, it's our position that we're willing to participate, but not carry the whole load in terms, in light of Mr. Papazian's own latches and failure to mitigate and waiting around 3 weeks to post up the bond, or I should say to file a petition. Thank you.
Mr. Nichol, are you consenting that this court this morning is the proper place to have this petition heard?
Yeah, by proceeding before your honor, I think it's implicit that we're waiving, but I suppose in all good fairness, we should voice that fact that yes, the petitioner waives any requirement that the statute might invoke that would have a court with a magistrate have the magistrate preside. So petitioner is fully confident that your honor should proceed and waives any right to proceeding before a magistrate and having an appeal to the district court. I suppose any appeal would have to go to the circuit court from your honor.
Same question, Mr. Austin.
Yes, Your Honor. My client is fine with you hearing this initially rather than having a magistrate do it. We would stipulate to that fact.
Thank you. I asked that specific agreement because Mr. DePietro raised it. Additionally, Mr. Nichols' brief or reply indicated that this court bifurcated the case so that two parts were here and two parts will be heard at another point. And that's not exactly what happened on June the 4th. What this court indicated was that the petitions that were filed back on June 24, 2024, identified two specific vehicles, and the court would not allow the record to expand other than by stipulation of the parties. You can't just continue to add equipment, cars, or flatbeds, or whatever the other pieces are by mentioning them during the course of a hearing. There has to be some agreement by the parties or an amended petition or something else other than just referencing the 1980 Kenworth and whatever the fourth piece was when we were here on June the 4th. So it's not a bifurcation. It's just keeping the parties to the documents as they have been filed with the court. So those two procedural issues having been addressed, Mr. Nykel, if you're prepared to call your first witness, sir.
I am, your honor. And with respect to exhibits, the exhibits that I plan on providing to the court were attached to my client's brief. I had also previously sent exhibits to the court, but these are all of the exhibits. I added a few that were more along the lines of the corporate and or LLC documentation from Lara. Does your honor want to have me mark these as we go for entry before the court, or how would you like to proceed with this? I'm going to be using exhibit 1 first. I'm going to kind of go down through the exhibits, but somewhat out of order.
If you want to retain the numbers as they appear on your reply brief, we have them as 1 through 25, I believe it is. And there's a proof of service showing that they have been transmitted to both Mr. Austin and Mr. DePietro. I'm not sure if you want to do it as a screen share or if Mr. Austin and Mr. DePietro have the filing readily available and are able to forward to the specific exhibits. I have no preference on how we do it. If you reference, Mr. Nykel, if you reference a specific exhibit.
Okay, this is
I guess screen share it is, that's fine.
Exhibit 1. Okay. I call Paul Papazian. State your name.
Paul Alexander Papazian.
Mr. Papazian, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Please proceed, sir.
Mr. Papazian, show you exhibit what's been marked as exhibit 1 in this petition. Can you identify that document that appears on the screen before you?
It's the original towing bill to Best Asphalt
And
from J&M Towing.
and who is Complete Diesel?
At that time, I was.
You meaning you what? Were a member? Is that an LLC or a corporation?
Was an LLC.
And you were the
So,
member, you were a sole member of that?
yes, sir.
And you're also the registered agent, correct?
Correct, sir.
I'm gonna show you, Exhibit 21. Previously identified as. And this is a record. You identify this record sideways, so it's kind of hard to see, but if you tilt your head, you can. Fortunately, that's how it came out from Lara. You see what that is? You see the name at the top of it under Department of Licensing and Regulatory Affairs.
I do.
What does it say?
Complete Diesel Repair LLC.
And you are the listed as the resident agent, correct?
That's correct.
But you also you identified previously that you're the sole member of that. Anyone else involved in this LLC?
No, sir.
What does, back to Exhibit 1. What did this establish between Complete Diesel and Best Asphalt? What did this tow bill indicate to you?
It's the first day I was storing those vehicles at Best Asphalt.
What was the date?
11/10/19 or 2020, I'm sorry.
Okay, and there were how many vehicles?
I want to say there were 8 vehicles, 8 trucks, and I want to say there was at least 6 or 7 semi-trailers at that time.
So this was a tow bill for how much?
$1,400.
Okay, and that was paid actually to J&M Towing, correct?
That's correct.
Did you have an agreement with respect to leasing space at Best Asphalt with someone?
Yes.
Who are you dealing with at Best Asphalt?
Charles Stefanko.
And Mr. Stefanko, to your knowledge, was what at Best Asphalt?
Owner.
Okay. So he had the authority to enter into apparently to you, enter into an agreement for leasing the space for these vehicles to be stored, correct?
That's correct.
And did you keep those vehicles stored on that lot for a period of time after that? After
Yes.
the date that they were towed?
Yes, sir.
About how long did you have vehicles stored at the Best lot?
Till they were towed on January 4th, 2024.
And did you have a written agreement with Best Asphalt and or Charles Stefanko to lease space there?
No, it was a verbal agreement.
Were there terms that you understood that you were required to follow in terms of a date when payment was due?
Yes, the date, when the payment was due, if Charlie wasn't there, I had to pay his secretary, Barb. She would give me a receipt.
And generally, how did you pay?
For the first year, I had to pay cash.
I'll show you Exhibit 2, previously marked. Can you identify that document?
Yes, that's a check that we wrote for storage,
Okay, it was written,
1/27/23.
but this kind of skips ahead, doesn't it? What's the date of the check?
It's all you were paying.
1/27/23.
So what about payments previous to this? Do you recall how much you were paying in lease payments to Best Asphalt monthly from the beginning?
From the beginning, it was $1,100.
Every month you
Every
paid
month.
$1,100.
Yes.
And generally by check?
First year it was cash.
It was cash. And why was it cash?
That's the way Charlie wanted it.
Okay. But you got receipts. Are you able to find those receipts?
I'm still looking.
Okay. Not, isn't that means no,
At this moment, I don't have them on my possession.
right? So, between January or November 10th of 2020. Well, let's go back. Looks like you paid, is there a payment date here on the tow
14th.
bill? Well, that was where you paid the tow bill.
Yes, sir.
So on that very same date, would you have, do you know when you made your first lease payment?
I want to say it was the 14th after all the vehicles were towed over there. They were put in a certain spot that he wanted them, and I gave him the cash that day.
So it was November 10th that you actually contracted with J&M Towing,
That's correct.
but they weren't actually moved on that date.
Some were moved on that date, but the final day was the 14th.
Okay, so it was a process, and ultimately you paid the tow bill November 14th, 2020. So you have no knowledge of whether your first lease payment and paid in cash to Charles Stefanko was whether it was on the 10th of November of 2020 or 14th of November, but you think it may have been the 14th because that was the last day.
I'd like to know what day the 10th was of 2020, because I think it was a Friday and I didn't get to my bank till that following Monday, but I don't want to be held to that.
But you had, do you believe some of the vehicles or trucks had been stored starting as early as the 10th of November? Or you have no way of really knowing?
I can't testify to that.
It certainly wouldn't have been before November 10th of
No.
2020.
Absolutely not.
Okay. So in terms of payment, you generally, what did you consider to be the due date of, in the absence of some written agreement or other understanding, when did you expect rent or lease payments to be due?
I anticipated the 10th because it wasn't prorated, but I did my best to pay it whenever he either called me or texted me.
And you say it wasn't prorated. What does that mean exactly?
Well, I paid for the whole month of November, even though I wasn't there the whole month. I want to say I was there half the month.
You paid for the whole month of November, or you paid? Okay, but it really, did you feel that the due date was established to be did you feel it was the 1st of November? It wouldn't have been the 1st, would it?
No, I wasn't even in contact with him by then.
So your payments would have then been due, was the due date in your mind for payments going forward?
Looking at the tow bill, I would assume that the 10th.
Okay. The 10th of the month, correct?
Correct.
All right. And then there's Exhibit 2, check in the amount of $450. Why do you not have receipts? We already established why you didn't have the cash receipts for that first year, but in terms of later payments after after that, why did the lease payment go down to $450 on January 27, 2023, when you wrote this check from Overhaulers Trucking?
And I think it was November of 2022, we ended up moving all the semi-trailers out. And then Charles had his guys move my equipment to a different area of the back lot, which was a smaller area, and he lowered my rent.
And at that point, you were now established well enough with Charles Stefanko that you could write checks?
Yes, we were writing checks before that out of another company.
What other company was writing checks prior to this?
Overhaulers Trucking Group.
Was that a corporation or an LLC?
It's incorporated.
And who was the principal or stockholder president of that
Michael Cascade.
And he was what with you?
He was using the trailers to store material in at my employment.
You worked for him?
Yes,
Okay, so the, and you don't have those canceled checks?
No.
Is that how they were paid, with check
they're all paid with the check.
by that entity?
Yes,
And you're no longer employed by Mr. Cascade?
no, sir.
Is that a yes or a no? You
No,
were-
I'm not employed by Mr. Cascade.
So, and when did that end, that relationship between you and Overhaulers Trucking Group Inc. and Michael Cascade end?
December of 2022.
Which is why then future checks came through Overhaulers Trucking LLC, correct?
And American Cross.
We'll get to that in a moment. Who signed this check?
Jim Beaupre.
And what does Jim Beaupre, what does he have to do with Overhaulers Trucking?
He was the employer at the time.
Employer or employee?
Employer.
At the time, so he's no longer employer, have anything to do with Overhaulers Trucking LLC? Okay, but he did on January 27th, correct?
Yes, sir.
Okay. Moving on to Exhibit 3, I'll show you now a check. Can you identify that?
So rent check on March 10th of 2023 for rent at Best Asphalt.
Okay. And it's written on an account held by what entity?
American Cross Dock and Distribution Systems.
And who has control over that entity?
James Beaupre.
Show you Exhibit 22. Maybe with this, if I show you Exhibit 22, you previously testified that at the time, Overhaulers Trucking LLC was controlled by James Beaupre. I want to show you what's marked as Exhibit 22, stated articles of organization. Date of this filing was March 24th, 2021. Does that refresh your memory as to who controlled American Overhaulers Trucking LLC?
That time I was.
Okay. So did James Beaupre ever have any relationship with?
I want to say we closed Overhaulers in January of 23 and went to a different MC number.
Okay.
Motor carrier number.
All right. Well, then I'm going to show you Exhibit 23 relating to American Cross Dock and Distribution Systems, whose name appears on that.
James Beaupre.
So was that the entity that James Beaupre controlled?
Absolutely.
As he was the member of, were you involved in that or in any way other, just as an employee?
Employee.
Okay. So back to the check exhibits. Left off at 3. Exhibit 3. American Cross Dock wrote that in. It looks like you signed. Is that your signature or not?
It's my signature.
Oh, okay. So you were actually a signator on that, on the American Cross Dock Distributions account, correct?
That's correct.
And looks like it was endorsed. Do you know whose signature that is, or can you identify it? Does it look familiar to you?
Looks like Charles Stefanko's signature.
Okay, but you weren't probably present when that was endorsed, correct?
We'll stipulate, Judge.
Thank you.
Thank you.
Exhibit 4, we have another check dated April 21st, 2023. Also who signed that
I
check?
signed that check,
And it was in the amount of,
$450,
and that was for rent for,
March of 2023.
okay, then we move to Exhibit 5. Also, who wrote the check?
James Beaupre wrote that check.
On American Cross Dock, correct?
Yes,
And the amount of,
$450.
doesn't say in the memo for what, but this was for what, given that the previous document was for March.
For the rent for the month of April.
Okay. Exhibit 6. And it looks like Exhibit 5 was also endorsed for deposit, correct? And
Yes,
then Exhibit 6, you identify that,
rent payment for May,
also drawn on,
American Cross Dock and Distribution Systems,
signed by,
myself.
and
Excuse
endorsed.
me, Mr. Nichol. I'm sorry, Judge, may I interject for a second? We'll stipulate to these checks and transfers and endorsements as they appear on their face.
Okay. So I can move through these. I would then ask Your Honor to admit exhibits 1 through 12, which are the tow bill, and then the checks, exhibit 7, 8, 9, 10. Want to ask you though about something that happened here but ask Your Honor to admit these exhibits. I'm sorry, I would stay with that. Exhibit 12, I think, was the last check. December 15th, 2023. And then the also exhibit are you also stipulating, Mr. DiPietro, to the exhibit 13, which was the rent summary that cataloged those payments that were listed on the checks? Or do I need to address that?
If I may respond, Your Honor, yes, I need something because I don't know that summary reflects the exhibits 1 through 12.
Okay, then we'll have to proceed, I suppose. With
So I'm sorry, by stipulation,
through 30
the total receipt and the payments, the checks.
through, yeah, that would be through exhibit 12. 1 through 12, I believe, are stipulated, and would ask for the court to admit them.
No objection, Your Honor.
Thank you. Mr. Austin, do you take any position?
I'm fine with I don't think we have a dog in that fight, so I'll stipulate to them too.
Thank you. Court will accept exhibits 1 through 12 by stipulation.
Going back to an exhibit that has been admitted by the court. See that a check exhibit 10 shows what to you, sir?
was a cash payment, and that Barb received the cash payment for the month of October 2023.
And that, what was the date of that? Oh,
11/21/23.
so what had happened, is there a missed payment?
I got a text from Shane saying that Charlie called him and wanted him to tow my equipment out, that there was a payment missed. I was in the hospital at the time, and I called Jim Beaupre, and Jim went over there and made a payment,
I'm gonna show
cash payment.
you mentioned the text. I'm gonna show you, exhibit 19. Can you, identify, is this the text you're referring to?
Yes, sir, it is.
So who is Shane?
He's a tow truck operator at J&M Towing,
And you've known him for a period of time?
20 years,
Didn't hear that, sir.
20 years.
Thank you.
What did so essentially, he advised you that you needed to do something. What was that?
He said that Charlie had called him, wanted to impound my trucks and have them towed out tomorrow. Then I stated to him that I was in the hospital, and I would send a representative over there to clarify any matters. After I got,
Excuse me, Mr. Papazian. Judge, I need to interpose an objection at this point, if I may. Are we testifying from recollection, or is he adopting this document which hasn't been admitted, or what? I would appreciate some clarification on that so I know whether to object or not.
Mr. Papazian, do you have an independent memory of this text having been received by you?
absolutely,
And you're not just reading the text, are you? Are you testifying as to what it was that Shane sent you? Shane from J&M Towing sent to you? Advising you of what? What did he tell you?
he said, I gotta tow my trucks out of there because I'm,
Judge, I'm going to object to the form. Could we make an admission? He could offer that as an exhibit. If he lays a foundation, we don't have to worry about it. Otherwise, I'm going to have some trouble with what he's testifying from
So
with
what-
the document on the screen in front of him. I
I'll
don't
answer
have an
the
objection
question.
either way.
That's fine.
Thank you, Mr. DePietro.
Mr. Papazian, so looking at this, where did this come from? This, can you identify what this is?
text from Shane at 10:47 in the morning.
On what date?
22nd or the 23rd of November. I have that. I can get it off my phone. I have that on my phone here.
I'm gonna,
Mr. Nyko, respectfully, I'm trying to figure out when we're going to get to January of this year.
well, we're gonna do that very soon, Your Honor, when we get to establish that rent was all paid, but trying to show, Your Honor, that there was some knowledge by both J&M, certainly at that time that these vehicles were Mr. Papazian's, and that he needed to do something in order to not have vehicles impounded, which he did then promptly do.
He did it on Monday, November 20th at 9:09 in the morning.
And
It-
may I proceed, Your Honor?
Can I interject for a second, Ed? The witness is looking at his phone and he is confirming a date that he received Shane's message, date and time. And he's confirming that he responded at the dates and times shown on the text. If that's his testimony, then I don't have an objection to its admission, because he's qualified it. There was no date on, Shane's, text to him, but he's provided it. So, I don't have a problem if he wants to enter. No objection,
Okay,
if there's an offer.
then I would ask Your Honor to admit Exhibit 19.
No objection, Judge.
No objection.
Thank you. 19's received.
Back then to the chronology of payment. So looking at that receipt, it was for October, but it was dated November 21st. Was there also a payment made just prior to that? I'm going to show you Exhibit 11. Is that refresh?
Yes,
So also wrote a check November 20th, 2023. Is that correct?
that's correct. Jim wrote it. Jim went over there and paid it.
So two payments were made in November, correct?
Yeah.
One on the 20th and one on the 21st of
Yes.
November, correct?
Yes.
Okay. November, Exhibit 12, I'll show you the last of the checks. What does this show? This is a check, correct?
The judge's objection, asked and answered, this was stick to, and it's part of evidence. We're going over it again.
But I just want to point out something, a nuance about this check, Your Honor.
I'm sorry, your response to the objection.
Well, when you say asked and I disagree, it was asked and answered. I'll move on and I'll just specify, I'll look to the specific nuance that I wanted to point out in this check, Your Honor.
It's in evidence.
Okay, now I got it.
So may I proceed, Your Honor?
Mr. Nykel, again, here's the issue. This case was scheduled at 9 o'clock. We didn't start till 10 o'clock. We are an hour into this, and I'm wanting to get us to January of this year. I understand that there's a payment history, but there's got to be a quicker way for us to move through this.
Well, this is December 15th of it's only a few weeks before January of this year, Your Honor.
We received number 12 in evidence, and I guess, Mr. Nykel, respectfully, we've already admitted this. What is it on number 12 that you want us to look
I
at?
simply want to ask Mr. Papazian if he wrote in the memo line November 2023.
No, I did not. I put December of 2023 on there. Somebody else wrote November,
But not you, Your Honor.
not me.
Okay.
No.
That's all I wanted to show, Your Honor, that this check was altered by someone, but it wasn't by my client. What did you in fact write on that memo line?
December of 2023. I abbreviated December.
Thank you. December, and then Exhibit 13. Can you identify this document?
It's my payments to Best Asphalt from the 1st of January 2023 to 12/31 of 2023.
Are these entries accurately summarize all of the checks and or cash receipts issued in this exhibits 1 through 12?
Yes,
So rent was paid or lease payments have been received or tendered to Best and or Stefanko for what period? December would have encompassed what to you?
to me, it would have included up until the 10th of January of 2024.
Your Honor, I'd ask that this Exhibit 13 be admitted.
No
Mr.
objection from
DePietro,
J&M.
Mr. DePietro,
Second.
thank you. Exhibit number 13 is received.
Exhibit 15, 16, I'm going to skip ahead. Exhibit 16 was can you identify that document?
That's the police report that I got on the FOIA.
Why was a police report generated? Can you show the date? Can you see what date that was?
4th of January,
4th of January of what year?
2024.
You did not prepare this document, did you?
No, I got it at the Romulus Police Station.
Does it fairly and accurately state what occurred on January 4th, 2024?
I didn't receive the report till they cleared it. A sergeant had to sign for it to approve it, and I didn't get it till the 23rd of January.
Why was that? What happened on January 23rd that prompted that?
They sent a TR form out, and I went to the police station, get a copy to talk to them about the 4 vehicles.
And there was issues of proof of ownership.
You know, the last 2 trucks were unidentifiable, and they felt that since they were commercial vehicles, that they would call CATS in to find out if they were stolen or improperly serial numbered, because they could not find any serial numbers on the vehicles.
What is CATS?
Commercial Auto Theft Division. Farhat's the one that told me that he called him.
Who's Farhat?
He's the desk, either lieutenant or sergeant at Romulus Police Department.
Your Honor, may I interpose an objection at this point? I believe, if I'm not incorrect, that this discussion and this current line of questioning pertains to vehicles other than those at issue today,
I join that objection.
and therefore irrelevant.
Well, Mr. I would, I can move from that and focus only on the vehicles that were at issue in the petition.
Just so the record's clear, then the objection is sustained regarding consideration of this document beyond the 2 vehicles that the court has identified as being at issue, the 1997s.
Thank you, Your Honor. The part of the interview did reference a Ford 1997 Ford truck with a VIN number 1FDLF47F9VEA 79283. Is that correct?
That's correct.
Who was that registered as the owner?
Nuts and Bolts Inc.
And Nuts and Bolts Inc. is a corporation that, what relationship do you have to that corporation?
The agent of that corporation.
Are you also a stockholder of that corporation or an officer?
Officer of that corporation.
What was your office?
Where's the, I don't understand the question.
Well, what office did you occupy with that corporation?
Ownership.
Okay. Were you president? Were you the only officer?
Yes, I'm the only officer of that corporation.
Believe as part of that police report, I'm going to show you attached to it were the titles, certificate of title, referencing Nuts.
Those are the other 2.
Here's, I'm gonna show you exhibit 24. Previously marked that, shows articles of organization. What is nuts and bolts, shown as, who's the,
Myself, Paul Papazian.
okay. This just confirms what you've already testified to, that you were it was actually an LLC, correct? Not a corporation.
Yes,
So the police report may have been inaccurate if it said incorporated. It was actually LLC.
yes,
You're the sole member of that LLC, correct?
yes, sir.
All right, I've that you admit exhibit 24 to evidence.
Mr. DePietro,
Just hold on a sec. I can't see he's moving it.
Oh, I'm sorry. There it is. Oh, that's not it. Here's 24.
No objection, Judge.
Mr. Austin,
No objection.
Is there another?
number 24 is received.
Thank you. Back to exhibit 16. But this vehicle, you actually, this was the 1997 Ford. You actually did redeem that vehicle.
Yes, I had to pay the tow bill and the storage fees.
And that was in conjunction with filing this petition before the court, correct?
Yes,
The other vehicle that is identified,
Peterbilt.
okay, and who is the owner of that?
I'm the owner. The corporation's called Project Load Express.
I didn't catch that, Your Honor. I'm sorry. Could you repeat that?
Repeat.
The company that's in is Project Load Express.
I'll show you exhibit. There's an inbound invoice for the F-450. That related to the property that was nuts and bolts. Is that correct? Okay. So you, in fact, either were the owner or the controlling interested
Project Load Express, yes,
for Project Load Express, which owned the Peterbilt,
that's correct.
the second vehicle. Looking at the certificate of title, you mentioned preferred. Oh, I'm sorry. That's not wrong. Yeah, sorry. There was a subsequent police report prepared in, it's marked as Exhibit 20. Did you, can you identify that,
I went to Romulus Police Department, did a FOIA on the version 2 of the police report of this under the same case number.
but this related to the two other trucks that were placed into that remain at J&M now. Is that correct?
That's correct.
Was there a reason that you could not get those vehicles? Couldn't either pay storage fees and or towing fees for those two subsequent vehicles, the two Kenworths? Why couldn't you just pay the impound and everything in January when you paid the impound for the two vehicles that were in fact redeemed?
Objection, Your Honor. Those two vehicles aren't at issue here.
Your Honor, the
I heard
reason,
you, Mr. Austin. I'm sorry.
reason for the question is a lot of time transpired between January 4th and or January 24th when Mr. Papazian was able to redeem the first two vehicles. He was trying to show the court why he didn't redeem those other two vehicles that aren't before the court in terms of the petition, to show the court that it was not by Mr. Papazian's fault in any way, shape, or form, that he was not able.
Mr. Nyko, that's not particularly relevant. The objection is sustained. The issue here is, were these vehicles properly deemed abandoned, and were the fees assessed reasonable? Now, the court has allowed this to go on for over an hour now, and I'm trying to get us to the issues that are identified in the petition that was filed in January. So please, let's get there.
I'm going to ask the court to, having spent some time authenticating the police report, I'm going to ask that the court admit exhibit or receive exhibit 16.
Mr. Austin and Mr. DePietro.
No objection, Your Honor.
Could I just see that again? I forgot what it was about now.
It was the police report that we've
Quit moving it,
gone
Ed.
over. That's all a lot of preliminary stuff. This was the nuts and bolts, Check Load Express.
And this is reflective of something that occurred on a certain date.
Yeah, it was the date, January 4th,
Okay.
port date.
Excuse me for a moment, Your Honor.
Yes, sir.
That was 16, Ed?
Yes.
Yes, sir. Sixteen's received.
Thank you, Your Honor. Just going to quickly forward to the
No objection.
Mr. Papazian, backing up a little bit, on after you made your payment, the last payment by check in December, did you ever receive any notice from Best Asphalt or Charles Stefanko relative to the lease being terminated? Any notice of lease termination?
Negative, no notice whatsoever.
And did you receive any communication from Mr. Stefanko in December by any means, either by telephone or text or email?
I received a text from him asking me what I was doing for the holidays. What's my plans for the holidays?
Do you remember when that text was received?
December 20th. I mean, I can look it up if you'd like.
I can, this was not provided as an exhibit, but I do have, Your Honor, no, I'm sorry. Did you reply to him?
I just told him I would be out of the country till at least the 5th of January.
This is hearsay.
This is what you told,
I texted him back.
okay? Your Honor, how is it hearsay? It's not an out-of-court statement offered to prove the truth of the matter asserted. Mr. Papazian was the person who made the statement.
Your Honor, I thought he was going to refer to what my client said.
No, talking about what you said to Mr. Stefanko.
Yes, sir. I replied that I would be out of the country till the 5th of January.
Is that true? You were out of the country? When did you leave the country?
That exact date, I'm not sure, but I did not come back on the 5th. I didn't come back till the 9th because of airline issues.
Were any vehicles removed from the Best Asphalt lot in December?
There were 2 that I know of that were towed by Auto Equipment Towing Company.
And that was you contracted with Auto Equipment?
That's correct.
And what were they able to move?
They removed another Peterbilt and another Ford 2 tractors.
Was it the intent, your intention to remove other vehicles at that? What was the date that was removed? Do you,
The 18th of December, I'm pretty sure.
and you know that from
Uh,
having researched your records, or
I got a tow bill from that date from Auto Equipment.
who was present on December 18th when those vehicles were removed?
From what I understand, it was
The foundation.
Okay, with respect to the vehicles, were you present at the scene on December 18th, 2023, when at the J&M yard? I'm sorry, at the Best Asphalt yard.
I got a text from the Auto Equipment saying they couldn't find the equipment. I texted Charlie back and said, could you show the record driver where the equipment's at? He said, have him come to my office and my son and I will put marks on the equipment that needs to be towed out of here. Make sure he checks in when he comes in back. And then they went back there and showed him where the equipment was. So no, I was not on the compound that day.
Did you, but the 2 vehicles were removed. What? Was there an attempt to remove other vehicles?
I was told there was an attempt to move other vehicles, but they had some.
Get the hearsay, Your Honor.
Okay. I have Your Honor, I have the tow truck driver on the ready to testify. His name is Chantel Sims. I have to text him and have him dial in. The owner of the and the truck driver, or the wrecker driver that actually moved the two vehicles. So I'm prepared to present that to the court. But I'll have to
Mr.
text.
Knight, we're still in the same place as to getting to the issue of the vehicles being deemed abandoned and the reasonableness of the fees. I'm asking you again, are we getting there soon?
Well, if I have to address the foundational issue of since my client wasn't present when vehicles were removed.
I'm sorry, Mr. Nykel, just so the court's clear, you're talking about the removal on December 18th, right?
Correct.
That's him.
Okay, I'm on January 4th.
Right.
Am I misunderstanding when the two 1997 vehicles were towed?
No, Your Honor, what I'm trying to show to the court was that there was an effort being made to remove all vehicles from the best yard on December 18th, but they were not able to remove 4 of the vehicles. Those were the ones that remained. And Mr. Stefanko knew that, as well as his son. They could not be moved for reasons that they were in disrepair. They didn't have inflated tires, so they had to have the tires repaired in order to properly tow the vehicles. And then those were the vehicles then that were left. And to show the court that my client had no intention of abandoning them and never received any notification, anything further until they were actually removed. And so that's what I'm trying to show you. May I proceed then with?
Absolutely.
Okay, so to your knowledge then, Mr. Papazian, 4 vehicles remained on the best asphalt lot on December 18th, 2024.
That's correct.
And that 2 had been removed. There had been 6, which is what you were paying rent for, right? 6 vehicles you were charged $450.
That's correct.
And you had made that December payment that had you paid up through January 9th, 2024, correct?
That's correct.
And no further notice was given to you when those, correct? No,
Yeah,
as to
nothing.
any removal. The 4 vehicles that were moved to J&M Towing, how were they taken? How were they taken to the J&M yard?
Yeah, I don't know. You have to talk to Jim.
Were the tires inflated? Did that ever happen?
No.
So was there damage to those vehicles because of it?
From what I've seen, yes.
What kind of damage?
Well, I do know that, I was looking for the serial number on one of the trucks, that only one nut was holding a steering tire on. The other ones had been broken off and both tires were uninflated.
So they essentially were dragged?
I can't make that comment because I wasn't there, but they weren't inflated, I can tell you that.
I can have Mr. Sims testify if Your Honor would like to hear his testimony. But it's basically just to show the court that vehicles were removed. The plan was to remove all, but they couldn't. And that's it with respect to that.
I don't know who else could testify to that besides Mr. Sims, Your Honor. My objection is anything he's going to bring up through Mr. Papazian is hearsay. Let's get the guy who was out there and find out why they weren't towed, and if he was hired to tow them.
Happy to text Mr. Sims right now, Your Honor. I don't know if Your Honor wishes-
Mr. Nyko, respectfully, what the plan was is not the issue. The issue is on January 4th, did Best properly, as the private property owner, identify these as abandoned vehicles? And did J&M charge reasonable towing and storage fees for the vehicles between the January 4th tow and the January 24th redemption?
Okay, Your Honor, I agree. We won't proceed with Mr. Sims' testimony. I don't know that it's certainly fatal to the case. It's it just shows that there was an intent to move the vehicles, and that was not possible at the time, that there was an effort to get them fixed, but it was the holidays. I guess I can ask Mr. Papazian a couple questions about that. Mr. Papazian, did you become aware then that there was disrepair to four vehicles remaining on the Best lot on December 18, 2024?
Sometime after that, I was notified, yes. I don't know what that exact date.
Were you in town, or had you already left on your travels?
I was either on the verge of traveling that day or it was the next day.
So you weren't present to be able to do anything about those vehicles?
No.
Was there anyone that could?
I understand that while I was gone, Jim reached out to
Jim who?
Jim Beaupre reached out to Best Asphalt to see if they could help out with the tires, and he was rejected.
Objection, Judge. You know, here we go. We're trying to get the witness's testimony in that he doesn't want to call. Hearsay.
Well, that would be Jim Beaupre, who we also have as a witness, and we can bring him before the court.
The objection is sustained. And we're going to take a brief pause in the petitioner's testimony. These 11 o'clock cases are waiting and they're ready. I'll call them and we'll resume the testimony.
Okay, thank you, Your Honor. We'll try to line up our other witnesses.
I won't be long. 2403498LT, the Maxwell versus Michael Draper, your appearances.
Good morning, Your Honor. Sidney Katz, on behalf of plaintiff.
Michael Draper.
Thank you. Today is the day and time scheduled for the third hearing in this matter. Mr. Katz and Mr. Draper, you've had the opportunity to speak. How are we proceeding?
Your Honor, we do have a proposed consent judgment. This is a non-payment rent possession only case. Currently, there's a balance due of $2,468 of past due rent, $170 of costs for a total of $2,628. Mr. Draper has until July 10th to pay that amount. He was advised of MCR 4.201, and he did authorize me to submit it to the court with his verbal authority.
Thank you. Mr. Draper, is everything Mr. Katz just said true and accurate?
Yes, Your Honor.
And Mr. Draper, you were present back on June the 5th, 2024, at which time the court played a video that explained the legal rights you have available. Did you have any questions about those rights?
No, Your Honor.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No, I do not.
What is the status of your application for assistance with DHS?
It was denied for not being in the state of eviction. So after this, with the court papers, I can reapply because it wasn't a need for help, because it was just a hearing for non-payment in the eyes of DHS.
Understood, Mr. Draper. Mr. Katz's office will prepare a consent judgment that shows a total due, including costs of $2,628 with a pay or vacate date of July 10th. The court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Katz?
No. We're all set, Your Honor.
Anything else, Mr. Draper?
No, thank you.
Thank you, sir. That concludes this matter. You have a good day. You're free to go.
Thank you, Your Honor. Have a good day. Bye-bye.
This is 2403505 LT Metro Commons versus Whitney Burry. May I have your appearances?
Good morning, Your Honor. Attorney Elizabeth Ellison, P 82098 for the plaintiff. Ms. Burry, you're muted.
Yep, can you hear me now?
Yes.
Yes, ma'am. State your name for
Okay.
me.
Whitney Burry.
Thank you. Today is the day and time scheduled for the third hearing in this matter. Ms. Ellison, how are we proceeding?
Your Honor, we have entered into a conditional dismissal whereby Ms. Berry agrees that she owes rent in the amount of $1,449.03, cost of $199.68, the balance being $1,648.71 to be paid on or before July the 5th of 2024. With 4B checked, where if it's not paid, an immediate order of eviction could enter. I did explain her rights under MCR 4.201J. She gave me permission to sign and submit. She actually submitted payment while we were in the breakout room, Your Honor, but as it needs time to a few days to clear, that's why we entered into the conditional dismissal.
The payment would be in full satisfaction of the conditional dismissal?
That is correct, Your Honor.
Thank you. Ms. Berry, you were able to hear Ms. Ellison just now, and everything she said is true and accurate.
Yes, ma'am.
And ma'am, you were present back on June 5th when the video played that explained the rights you have available on this landlord-tenant matter. Do you have any questions about that, about your rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the conditional dismissal?
No, I think I'm good.
Then Ms. Ellison's office will prepare that document, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Ms. Ellison?
No, Your Honor.
Anything else, Ms. Berry?
No, I'm all set. Thank you.
You're welcome. You're free to go. You have a great day.
You
you,
as
Honor.
well.
We're back on the record in 2400518GZ. We'll resume the testimony of Mr. Papazian. Sir, you remain under oath.
Mr. Papazian stepped away for a moment. He's just entering right now.
That's fine.
And I have Chantel Sims dialing in very soon. He was driving and he had to pull over if he's allowed to use his phone. He has the Zoom code and I don't see him present. Chantel Sims is his name.
I remember. I'll keep an eye out for him. Let's resume the testimony. Or were you done with your client, Mr. Nykel?
Well, I believe we have covered everything, Your Honor. But as far as this witness goes, if there's any cross-examination.
Mr. Austin?
Thank you, Your Honor. Mr. Papazian, you have no idea what happened between J&M Towing and Best Asphalt regarding any telephone calls to remove the property. Is that correct?
Just
You
the
were
one
the
I
part-
got, just the one I got from Shane in November.
Okay, but on January 4, you were not a participant in those phone calls, correct?
That's correct, sir.
Okay. Do you have any, are you challenging the amount of the towing fees of J&M?
You're referring to the current ones or?
I'm referring to the two vehicles that are the petition here. Let's start with the Ford F450. Do you have any issue with the towing fees that were charged for removing that vehicle?
I mean, I think they're excessive, but it is what it is.
Okay, do you have anything to prove that those are excessive?
Not with me today, but
How about the storage fees?
I'm sorry,
How about the storage fees?
same thing with the storage fees.
Okay, so you have nothing that can show that those are anything but reasonable.
Personally, I don't think they are, but that's just my opinion.
Okay, on the other vehicle, same thing?
Talking about the Ford or the Peterbilt,
The Peterbilt?
same thing.
Okay, nothing further, Your Honor.
Thank you. Mr. DePietro.
Mr. Papazian, you, did not redeem these two vehicles, the Peterbilt and the Ford, nor post a bond until January 24th, 2024, correct?
That's correct.
And at that time, the bill had gone up to, for the two vehicles, $5,800, correct?
My understanding is yes, sir.
And at the time Peterbilt and the Ford was pulled, you were not shown as the title, correct?
On my corporation, I was.
So you were not on the title, correct?
I got to the court to file this paperwork. They said the state never notified me. They included the Peterbilt as it was under the same case, but they admitted in the court when I filed the documents that the state never sent me a notice for the Project Load Express Peterbilt.
Well, let's get back to what I was talking about. Your name was not on the title, correct?
My corporation was.
Well, in any event, you filed a petition with the court, seeking to have this court determine whether or not the fees were reasonable and who should be paying them, correct?
That's correct.
And at that time, your petition named Charlie Stefanko or Best Asphalt.
No, it's not correct.
According to the court records, you did not include that as an interested party to get notice on your petition.
The court wouldn't allow me to do it because the property was at J&M, and they said the way the statute was written, I could not include J&M, Best Asphalt, that it would be up to the court to add them or not.
So then you're saying that the court wouldn't let you put Best Asphalt and Charlie Stefanko as parties who may have been responsible for your loss. Is that correct? The
Just
court.
objection, Your Honor, just to clarify, we're talking about the court. Who are you referring to? The judge? I think there needs to be a proper foundation on this. As to who Mr. DePietro is referring to when he's referring to the court.
Well, Your Honor, the petition on file with this court filed by Mr. Nyko not include Stefanko or Best. And I'm just trying to establish that this witness, the court's record will speak for itself. And it was signed by Mr. Papazian.
Mr. DePietro, I believe Mr. Nykel's question is clarification of the court, not the court, capital C, courtroom number one, the court, but more likely lowercase c, civil clerk downstairs, probably Jack, or the civil clerk that took in the filings as the person who did not allow Mr. Papazian to add Best Asphalt or Charles Stefanko.
Thank you, Tom. Did some clerk tell you you couldn't do it, Mr. Papazian?
Clerk and the court officer that was in charge that day told me I couldn't either. Because I rejected the first guy's answer, and then I asked for a supervisor. The supervisor said no.
Now, you do understand that paragraph 6 of the petition you signed does have a box to include the owner of the property, doesn't it?
I'm not familiar with it, but they asked me where the property was, and I told them J&M Towing.
All right, so on January 24th, 2024, the last day during which you might have a successful redemption, you did not inform the court of the Best Asphalt being the private property owner or Charlie Stefanko, correct?
No, I did, but they wouldn't accept it.
Can we agree that the petition does not include a private property owner? Can we agree on that?
I think we can stipulate that. I think it doesn't, it clearly states that it doesn't have any property owner listed.
All right, that's fine. Thank you. Now, my next question, if I may proceed, Judge.
Yes, please.
Your petition on paragraph 5B says you received notice of the forfeiture on January 10th, 2024, correct?
No, that's the day it was mailed, I'm pretty sure.
You want to take a look at your petition?
Sure.
All right, well, your lawyer's got it in his hand. You signed it. Why don't you ask him for it and take a look at it and go to page 5B and we'll talk about what you said on your petition under oath.
Hey, Tom.
I'll tell you what you said. You said the petitioner received notice from the Secretary of State on January 10th, 2024 that the vehicle is abandoned, considered abandoned. Do you deny that?
I have to look at the paperwork.
Your lawyer has one. I'm sure you'll be happy to share it.
Here. Talking about 5B.
5B.
That was stated on the paperwork, the 10th.
And the paperwork you signed, correct?
Well, the paperwork from the state of Michigan said the 10th.
Do you agree with me, sir, that you informed this court on January 24th, 2024 that you received notice from the Secretary of State on January 10th, 2024 that the vehicle is considered abandoned?
No, it's not true.
So you didn't tell the truth on your petition?
Did tell the truth. That's the day it was mailed from the state of Michigan.
Do you see the word mail there anywhere? Of course you don't. It's not there. You told the court that you received notice from the Secretary of State on January 10th, 2024, and your lawyers established that you didn't bother redeeming those vehicles until January 24th, 2024. Isn't that true?
I'm not in agreement with that.
You're not in agreement with the petition you filed with the court? Is that your testimony?
I believe, Your Honor, I would object. It's asked and answered. It's get bordering on badgering.
It's not actually been answered, but the court takes notice of the pleadings that are on file with the court.
Thank you, Judge. Thank you, Your Honor. So had you shown up at J&M on January 10th, you'd owe 2 weeks less towing fees or less storage fees, correct?
I didn't get notice till the 23rd of January.
Are you changing your testimony now?
No, because Randy Ferguson, as the secure party, got the notices. I never got any notices.
But you told the court you did. Didn't you? Didn't you say, I got notice on January 10th, 2024?
That's when the paperwork was issued.
So now your testimony is that you received notice on January 23rd and you immediately proceeded to J&M on the 24th to redeem, correct?
Correct. Randy Ferguson came to my work and showed me the paperwork, and I proceeded to the Romulus Police Department.
So without you being on the title, they had to notify the secured party, Randy Ferguson? Is that what your testimony is?
They notified him. They didn't notify me on the Peterbilt at all.
Because you weren't there, right? You weren't on title.
Project Load Express was.
And so the Secretary of State and J&M should have known that Road Express was the owner of your vehicle?
And the court is the one that included the Peterbilt. They couldn't find any findings that the title was under abandonment.
So Who is Randy Ferguson?
He's the secure party.
And what kind of secured party? What do you owe him and why?
I'm not at liberty to speak about that.
You're not at liberty because there is no current loan agreement.
Well, there is.
How much for?
I'm not willing to divulge that.
Why is that?
I don't really think it's anybody's business.
Your Honor, I'd object because it's irrelevant.
How is it irrelevant? Excuse me, Judge, I'm sorry, I don't mean to respond. Yeah, I am claiming, Judge, that what Mr. Papazian is doing is he is creating liens on his documents so as to avoid attachment by judgment creditors, the IRS, in the state of Michigan. And that's where my testimony is going with regard to these so-called liens on his vehicles. He's leaning them up to prevent them from being seized. And he can't even tell us today what it's about, what the lien's about, how much it was about. And I think,
Respectfully, Mr. DePietro, it sounds like another issue for another court and maybe another law enforcement agency on a different day.
thank you, Your Honor.
Thank you, Your Honor.
You filed a bankruptcy in 2023, correct?
Yes,
Yes? Okay.
yes,
And did you declare your ownership interest in these vehicles and your various corporations as being an asset of yours?
yes.
And did the court issue a stay of proceedings for you in your bankruptcy case?
They ended up throwing the case out
Throwing your case out?
twice.
Okay. So you filed bankruptcy for what purpose? Were you attempting to avoid a creditor at that time?
No,
Your Honor, I object to this question. I don't think it's relevant
Well, Judge,
for the court at this time.
I need to build some relevance here. The state of Michigan shows that Mr. Papazian has formed 31 Shell LLC. And I want to proceed to discuss with him the purpose of these Shell LLCs and these false security agreements to dodge a federal tax lien, 2 federal tax liens filed against him, which are applicable or have been placed on the vehicles in question. I can go over with him the dates that they were filed. I'm sure he won't deny he's got federal tax liens that attach to the vehicles that he's got in J&M's yard and that he had in our yard. And by using these various corporations of which we have no proof that he has any interest in other than a resident agent, he's playing a shell game with creditors and the IRS. And that's why he's not answering my questions pointedly.
Your Honor, what's relevant before the court is, did Mr. Papazian pay his rent? Was he in good standing on January 4th, 2024, which he was? All of this other is just a bunch of more of a, to use Donald Trump's favorite term, witch hunt.
Well,
Mr. Nykel, the court respectfully disagrees with you. That is not the issue before the court. The issue before the court is when the private property owner, Best Asphalt, contacted J&M Towing to have the vehicles removed from the property on January 4th, 2024, and had them deemed abandoned. Was that appropriate? And then the part 2, defendant number 1, J&M Towing, charging reasonable fees and towing. Those are the issues before the court, and the court will agree with you, Mr. Nykel, that Mr. DePietro is going a little far afield with the federal tax liens and the shell companies, or the number of companies registered with the state of Michigan that Mr. Papazian is listed as an officer, resident agent, or anything else. Let's keep it focused on the issues as identified in the petition that was filed back on January 24th.
Your Honor, the issue that I am currently examining the witness on pertains to credibility. He's already attempted to refute the petition language he filed with this court and was very vague on how he got notice and when he got notice and who he got notice. And he's setting himself up for a credibility argument. Now, under Laher versus the Laher decision, excuse me, People v. Laher, 464 Mich. 756, I can examine on credibility issues, even though the
And Mr. DePietro, just as respectfully, I'm picking up what you're putting down when you asked them a question simply regarding the information that he, Mr. Papazian, listed in his petition regarding impoundment. You don't need to keep beating the drum with me, sir. I hear what you're saying.
Very well, thank you, Judge. I'll move on. I heard that part too. You do have certain corporations that you've formed or LLCs in the state of Michigan, don't you?
Many.
Many, right. What was the purpose for all that?
2009 to 2000, or from 2009 to 2019 or 20, I was an agent for a company called E.L. Hollingsworth in Flint, Michigan, who was the second biggest transportation company for General Motors. Under their rules, I could only employ 2 employees per company. We were running over 30 trucks. So I had to start an LLC on it, or an incorporation or a corporation, to employ those 2 people to drive truck.
And so you used 3 of those corporations to be a tenant of my clients, correct? I think you had Mr. Jim Beaupre having an interest in 2 of your corporations, and you sent him out to send checks and that sort of thing, correct?
Jim Beaupre used to be my employee.
He also signed checks, correct?
He signed it on, yeah.
Okay, I mean, the
As
checks.
far as corporations, yeah.
Okay. And it's fair to say, is it not, that at least as early as December of 2023, you knew you had to get those trucks out because you were trying to hook up with another tow truck person to take them out of my client's yard, correct?
I don't understand the question.
Your Honor, I would object. I don't think it's clear what Mr. DePietro is asking the client.
Rephrase, Your Honor. Didn't you
It's
test?
not clear to me, Mr. DePietro. Mr. Nykel, it's not clear where he's going with me. The answer to the question, Mr. Papazian, regarding attempts to connect with a tow truck driver in December of 23?
Did I hire somebody else to tow that equipment? Yes.
Right. No further questions, Judge.
Thank you. Mr. Nykel, before you redirect on your client, there is 2402763LT Royal Village versus George. The parties have had the opportunity to speak. May I have your appearances, please?
Yeah.
Mr. Robinson,
Morning, Judge.
good morning. What, Mr. George seems to have left us. You spoke to him this morning. What happened?
Yeah, Judge, we're in the breakout room, excuse me. And Mary Ann said to stay in the breakout room until you were done with the party. So we waited there, and then I think you came on, and user error, I pressed the wrong button and I had to get back. So, but yeah, we reached an agreement.
Well, Mr. Robinson, Mr. George was on the screen and now he's gone. What was the agreement, sir?
Judge, it was going to be rent in the amount of $1,645 in court costs for a total of $1,745, writ date 7/5/24.
And did you discuss how that document will be executed? Did you have his authority to sign his name, or are you giving it to him for signature?
Your Honor, we did not discuss that. So
He said we could call him back. if he got disconnected,
Oh.
because he was having problems.
Oh, yeah, he did say to call him back because he said he may have been having some technical problems. So you want me
I'll
to?
note on our, Mr. Robinson, I'll note on our end that that was the information discussed and agreed to by the parties. The court did receive from Mr. George documents this morning that were filed as an answer to eviction notice and the motion to stay that lists the 1,600 on there. So if you can get his signature and get that document filed, as long as the numbers match the numbers you just provided, the court will enter it. If he logs back on, I'll inquire of him regarding that agreement, okay?
Okay, so you want me to try to get him? I'm gonna try to get him back, Judge. Okay,
That's fine.
okay, let me just try that.
Thank you. 2403-426 LT West Village versus Foster.
Good morning, Your Honor. Ali Risk on behalf of plaintiff. I apologize for my voice today. I'm a little bit under the weather.
Understood, sir. Hope you feel better soon.
Thank you.
Patricia Prutnick, Your Honor, on behalf of Ms. Foster.
Thank you. Today was the day and time scheduled for the third hearing in this matter. How are we proceeding this morning?
Your Honor, we are currently in possession for a check in the amount of the amount asked. We would just like a control date to ensure that check goes through, and if that's the case, we will be dismissing this case.
Is that your understanding, ma'am?
It is, Your Honor.
Case is adjourned over to July 11th at 8:30 a.m. If the check clears and you're ready to dismiss it, just have the dismissal file beforehand and we'll get it processed and get the adjourned date removed from the docket. Was there
Yes, Your
anything else,
Honor.
Mr. Risk?
No, thank you, Your Honor.
Nothing further,
Anything
Your
else,
Honor.
Ms. Proknick? Thank you. Have a good day.
Thank you, Your Honor.
This is 2403-442 LT West Village Estates versus Kelly Kirkland.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
It's not Kirkland. Ma'am,
Yes, ma'am. I'm here.
state your name for me. I know it's not Kirkland.
No, it's not. It's Kelly Smith, but it's Kirkland on there. Yes, ma'am.
As soon as I saw your face, I remembered that's not the right name and I just didn't have it written on the side. Today was the day and time scheduled for the third hearing in this matter. The parties have had the opportunity to speak. How are we proceeding, Mr. Risk?
Your Honor, we were able to reach an agreement in the form of a consent judgment. I have the numbers when you are ready.
I'm ready.
Thank you, Your Honor. The rent to retain is $1,565.66. Court costs up $182.68. Total $1,748.32 with a writ date of July 8th, 2024.
Ms. Smith, you were able to hear Mr. Risk just now?
Yes, ma'am.
And was that an accurate statement of your agreement?
That is correct.
And you were present back on June the 5th when the court played a video that explained the rights you had available in this matter. Do you understand those rights?
Yes, I do.
Do you have any questions about today's proceedings?
No, ma'am.
Any questions about the consent judgment?
No, I do not.
Did you agree with Mr. Risk that he would sign your name to that agreement, or were you intending to sign it yourself?
I agree that he could sign it. He has my permission.
Thank you. Then his office will prepare a consent judgment that shows a total due of $1,748.52 with the indication that you will pay that amount or vacate by July the 8th. So long
you
as the
say-
document he submits,
I'm sorry to cut you off. Did you say 52 or 32?
I said 52, but is it 32, Mr. Risk?
It's 32 cents. Yes, Your Honor.
32, thank you. 174832, so long as his document matches those numbers, the court will sign it and a copy will be mailed to you at the address we have on record. With that clarification as to the balance, was there anything else, Ms. Smith?
No, ma'am.
Anything else, Mr. Risk?
No, thank you, Your Honor. I do have a couple more I'm trying to work out.
I know you do. We're
Okay.
in the middle of another proceeding, but if you conclude with Ms. Morris and Ms. Strode, I will take a recess. I'll take a brief adjournment for the other two,
Wonderful.
for the
Thank you
other
so
case
much.
to get your last two done. Thank you.
Great. Thank you, Your Honor.
Yes, Mr. Robinson.
Yeah, Judge, left a voicemail for Mr. George, so I can attempt to get his consent or get his signature on the consent, so I'll take it from here.
Thank you.
Thank you, Judge.
And then for the towing case, I'm stepping off for 1 moment, but don't go far, it'll be less than 2 minutes.
All right.
If you're ready to resume testimony in 2400518 GZ. Mr. DePietro and Mr. Nykel.
They gave up, Judge. Let's go.
I assume when someone's video is off, they're not quite ready for me, and I'm here waiting to see if these last two 1115 cases are ready. So I'm ready to resume the towing case. Marianne, if you need to leave, my feelings won't be hurt. Okay.
No, ma'am, I'm not going anywhere.
That's defendant number 2. Let's see if the petitioner's ready.
Waiting.
Guys are long-winded, isn't he? Ed? Yeah.
Mr. Nykel, if you're ready to redirect on your client. You're muted, sir.
My apologies. There we go. Mr.
Did you have
Papazian.
redirect for Mr. Papazian?
Yes, Your Honor.
Okay,
Just back to the question that was raised by Mr. DePietro as to your petition, paragraph 5B, check the box, petitioner received notice from the Secretary of State on January 10th, 2024. Did you understand that was the date? What did you understand that question asked?
I understand that's when the paperwork was generated for the TR form.
And was that in fact the date on the TR form of January 10th, 2024?
Yes,
So when you put that date down, that was your intent, was to show that that was the date that the Secretary of State sent notice,
yes, sir.
but you didn't actually receive it, correct?
Didn't receive any statements.
You testified that it was received by Randall Ferguson, who was a secured party on one of the vehicles, and that he brought you the notice and you acted almost immediately, I think the very next day. Is that correct?
That's correct.
Because you in fact received notice from him on January 23rd, 2024.
That's correct.
Okay. Do you know why notice? Have you been able to determine from any information you've gained as to why you would not have gotten notice from the Secretary of State?
I called up to the Secretary of State and they didn't have any answers why they didn't send any paperwork out on the Peterbilt. And they couldn't explain it to me. When I got to the court, they told me that since it had the same case number that the police wrote the report up, they would include it. That's the only reason it got included.
So I think that's all, Your Honor. I don't have any further redirect on this.
thank you. You're pointing, Mr. DePietro, was there something else? You're muted, sir.
I wanted to ask the witness if he thinks one of the reasons he didn't get notice was because he wasn't on the title. Since he gave us a reason.
No, I should have gotten it. No, I should have gotten it.
And how did Mr. Ferguson inform you of the fact that he had notice?
He came over to our work. He drove over and showed it.
Showed it to you.
Yes,
Is that your testimony?
yes, sir.
Did you ask him why he waited so long?
He said he just received it.
No further questions.
Thank you. Anything else, Mr. Austin?
Nothing, Your Honor.
Anything else, Mr. Nykel?
Your Honor, Mr. Sims was on our Zoom while.
Anything else as relates to Mr. Papazian?
Sorry, no, Your Honor.
Thank you. And I saw Mr. Sims and it looks like he was still in a vehicle. I'm not sure what happened to him. Was there any other witness you intended to call this morning, sir? Or this afternoon now?
No, not, Your Honor, the petitioner rests.
Thank you. If Mr. Sims logs back in, I'm happy to have him sworn and take his testimony.
Yeah, good. Thank you, Your Honor. I texted him. And he hasn't replied. I can only assume the busy life of a record driver. Who's the owner?
No worries. Mr. Austin, any witnesses, sir?
Just one, Your Honor. I would call Valerie Welch from J&M Towing.
Sister.
And I'll try and keep it brief, Judge.
Daughter.
I'm here till 4 if you want to keep it long.
I
From
don't want,
J&M Towing, would you state your first and last name and spell them both for the record, please?
My name is Valerie, Valerie, Welch, Welch.
Ms. Welch, would you raise your right hand for me, please, ma'am? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Austin, you may proceed.
thank you, Judge. What's your position at J&M? Well, sir, do you work for J&M Towing?
I do.
What's your position there?
I am the office manager, dispatcher.
Are you familiar with the matter that we have before us today in court?
I am.
And are you familiar with the records and the paperwork and the documents that have all come through J&M?
Yes.
On January 4, was there an instance where Best Concrete or Best Asphalt contacted J&M Towing for something?
Yes.
And what was that for?
We were requested for a service to come out and do a private property impound on 4 tractors.
And
one-
what's a private property impound?
Private property impound is where a property owner will call us to come remove abandoned vehicles or vehicles that have been left on the property without the permission.
Okay. And was it made clear to you that the vehicles were on the Best Asphalt property without the property owner's permission?
Correct.
The statute MCL 257-252A11 requires a towing company, when they do a private property impound, to contact the local police department and report that that impound is going to take place. Do you know whether that occurred? Did J&M contact the Romulus police?
Yes, my driver contacted Romulus Dispatch when they arrived on scene.
And what occurred?
The dispatch told us to go ahead and bring the units to our yard, and they would come later that day and write up the impound slips from our property.
And did that happen?
Yes, they were able
Go ahead.
to make the 2 reports. The other 2, they were not able to pull the VINs from. So they were not to write the slips up.
And the 2 vehicles that were involved that they did get the VINs for, and that's a vehicle identification number, were which 2 vehicles?
That was, I believe, the Ford and the Peterbilts.
Okay, which are the 2 vehicles that are subject to these 2 petitions?
Correct.
So J&M Towing contacted the police department, got the information to them, and then what happened? Did you proceed to store the vehicles?
For the remaining 2 or the?
No, just the 2 that we're dealing with, the Ford and the Peterbilt.
To Mr. Papazian on the 24th of January of this year.
Okay. And Mr. Papazian came and redeemed those vehicles?
Yes, and we towed them to his property in Lincoln Park per his
Okay.
request.
Are you familiar with towing and storage rates in the area for private property impounds?
Yes.
Are the prices that J&M charges for towing for private property impounds that were charged to Mr. Papazian similar to those that are charged by other towing companies in the Romulus area for private property impounds?
And the surrounding areas in Romulus, yes.
Okay. How about storage for a vehicle the size of the Peterbilt? Is the daily storage charged by J&M similar to the private property impound storage charged by other towing companies near Romulus?
Yes.
And how about the same question for the Peterbilt?
Yes.
I have nothing further, Your Honor.
Thank you.
You're welcome.
Mr. DePietro, any questions for Ms. Welch? You're muted, sir.
Apologize. Hi, Ms. Welch. I represent Best Asphalt.
Hello.
When you towed the vehicles in, do your records indicate whether they came in on a hook or flatbed?
They came in on wreckers.
That's a hook?
Yeah, well, that's the heavy duty truck.
Okay, you know the difference I'm trying to make here. One, you haul the vehicle up, put it on a flatbed. That ain't how they came in, correct?
So I know that some of them were brought in by the wreckers. Some of them were brought in with a Landau or a lowboy.
Okay. Do you know anything about the Peterbilt and the Ford, how they were brought in?
Let me take a look.
Okay, thank you.
You're welcome. It looks like the Peterbilt was hooked to a wrecker for tow in and tow out. And
Did you say tow in and tow out?
yeah.
The other one was the E450?
Yep. And that one also looks like it was hooked to a wrecker.
And when you say wrecker, I'm thinking of a hook. You're saying-
A hook.
Okay. So both of those vehicles, now, I think you indicated that your records also indicate that you brought those into Best's yard, is that correct?
I do believe so.
Okay. Why do you believe that?
Well, I wasn't working here at that time.
Did you see records that suggest to you that that's what happened?
Yeah.
Okay. So you were able to bring in, according to your records, these two vehicles on a hook and remove them on a hook. Is that correct?
That is correct.
Okay. Which means they rolled.
Right. I'm looking at the pictures provided in our system.
Are you looking at one of these on a hook? Is that what you're looking at?
Yeah.
Okay.
You want me to show you?
No, that's all right. I'm fine with it. I think your testimony. All right. Thank you, Judge. I have no further questions. Thank you, ma'am.
Thank you.
Thank you.
You're welcome.
Ms. Welch, you're not done yet.
Okay.
Mr. Nyko?
Unmute, there we go. Thank you. I'm gonna ask the witness, hi, how you doing today?
Hello, how are you?
Yeah, good. Exhibit 15 has been previously marked by the court. And is the court able to still see my share screen, or do I have to?
No, I took it down so that my secretary could move the parties around. But you should be able to share your screen now.
Yeah. Here we go. Okay, exhibit 15. Can you identify with that document? I don't know how if you can see it very well. It's somewhat sketchy, but you have to turn your head a bit sideways to see.
Okay.
Does that look familiar to you?
I really can't read it, but what is that we're looking at?
Well, it's the Inkster police, I'm sorry, the Romulus police records of the dispatch. Do you have records that show what time the police were called?
I should have the impound slip. Give me one moment. Which one are we referring to on this?
Well, it would have been for both vehicles.
Okay. So
Let's see, I'm looking at it. I believe it would have been from all the private tows that were from Beverly Road. It was all done at one time, was it not?
So the Peterbilt and the Ford were written up on the 4th, the day they came in. They did visibly see all 4 trucks, but I do not believe that they wrote the impound slip for the 2 Kenworths that day.
You have records that would show that impound slips were that only 2 vehicles were towed on the 4th of January?
So all 4 vehicles were towed, and we can tell that by the incident number. They were all 4 under the incident number 2400000209. When the officers came out the day after I was provided documentation from Mr. Papazian, they wrote up the other 2 with the same case number, that referring to them being towed on the same date.
was the Romulus police called before the vehicles were towed?
Yes.
Your Honor, I'm going to object to the extent that we're talking about the Kenworths, because again, that's not a part of this. If we're limiting to the Peterbilt and the Ford, it's fine.
Your Honor, it doesn't delineate between, it says 4 semis on this exhibit 15, it refers to 4 semis to be inspected that were private tows. So I don't know how I can separate them, but
Well, you could, because she talked about the impound slips, which are exhibits 1 and 2 to my brief. And you could refer to those as opposed to the turn the head and try and read exhibit that's attached there for exhibit 15.
exhibit 1 and 2. Okay. So on exhibit 1, this is referring, I'm looking at your reply brief, Mr. Austin. This says, I'm trying to determine, this was the F97 Ford wrecker. Let me try sharing that.
We can see it.
Yep.
Oh,
I'm
you
looking
can see it right now?
at my computer.
Yes,
Okay.
sir.
Okay, thank you. That shows a date and time at the top.
Yes, sir.
What was the time of the call? Or that indicate the time that it was actually brought to your yard?
No. So that is the time that the slips were written up. And so these were brought in at 10:31 a.m. on January 4th, 2024.
10:31 a.m. they came to your yard.
That was when the call was put into the system, 10:31 a.m.
And back to exhibit 15. I show you at the top, it shows a time where a phone call. Do you see that record? If you look sideways, you see the report of the Romulus PD showing what date the call was received by the police. Can you read the time that's shown there?
It looks like it says 10:54 a.m.
Correct. So in fact, what your testimony is that you already had the tows in your yard prior to calling the police, correct?
No, this is saying that we received the phone call at 10:31 a.m. That's what my system is stating.
You received the phone call from, Best.
Yes.
Is that what you're saying? Oh,
that's what I'm saying.
So Best contacted you at 10:31. And is there any indication of when in fact you had the semis moved to the J&M yard?
It looks like this one says 12:12 p.m. January 4th.
And you're referring to the impound report, supplemental report that you mentioned as exhibit 1 and
on my system.
Oh,
the tow books system, it says that they were on scene at 12:12 p.m., which is when the next update was done on our side. But it states that the call came in at 10:31 a.m.
from Best, and then the call to the Romulus police at 10:53, I believe. 10:54 and 53 seconds,
Mhm.
correct?
Yes. So I'm
Uh,
assuming that 10:54 would have been the time that my driver reached out to the Romulus Police Department dispatch.
Your Honor, could I have just a moment to confer with my client?
How long is a moment, sir?
1 minute.
I just want to do some other things, so if you need more than a minute, that's fine.
Okay. Thank you, Your
Thank
Honor.
you. Mr. Risk,
Splitting hairs.
in 2403253 LT Trilogy versus Nicole Morris.
He's supposed to say he wasn't here.
Good morning, Your Honor. Ali Risk, so good afternoon, Your Honor. Ali Risk on behalf of plaintiff.
I could say something stupid.
Ms. Morris was here and I thought she logged on again.
Your
And now I
Honor,
don't see her.
yes, that's correct, Your Honor. So, Ms. Morris, we're unable to come to a resolution on her case. Last time we were here, Attorney McLenore from Lakeshore Legal Aid indicated that she'd be filing an answer to my complaint as well as an appearance. I haven't received such documentation. So I'm in a weird situation where I'm not sure if that was ever submitted. Ms. Morris says that they've communicated afterwards, so I'm hesitant to speak to Ms. Morris directly, knowing that she might possibly have an attorney.
Hello? Hello?
Yes, ma'am. Yes.
I'm here. Nicole Morris is here.
Yes, Ms. Morris, give me one moment. Mr. Risk, I'm looking in the court's file right now. And I do not see that anything was filed by Ms. McLemore. I don't see that this court has even received an appearance in this matter.
So, Ms. Morris, were you able to get in contact with them?
I was not. I talked to the lady, answered the phone, and then she transferred me and it went to a voicemail.
So, Your Honor, I would ask for a judgment then based on that, but I'll leave it to your discretion ultimately, of course.
He was saying something about the by the 8th, the 3,300 or something.
So, Your Honor, there would be a total of $3,339.71, which includes the court costs that would be payable on or before July 8th, 2024.
$3,339.71.
Yes, Your Honor.
The issue, Mr. Risk, and the reason why this court is reluctant to proceed without Ms. McLemore, given the nature of the conversation that Ms. Morris previously tried to submit $1,400 and the money was refused, that SCR DHS had approved another $400, but that your client would not provide the documentation to have those funds released. There were some questions about the excessive nature of the late fees. So over your objection, Mr. Risk, the court will adjourn this matter over to our July 11th docket at 8:30 a.m. Ms. Morris, notice cannot be sent to Ms. McLemore. She has not filed an appearance, but that will be the last adjournment of this matter. If you're able to convey that information to her office July 11th at 8:30 a.m., we'll take it up at that time. She just needs to file an appearance and appear on your behalf on that date, okay?
Okay, July 11th at 8 o'clock.
8:30, ma'am.
8:30, okay.
Back on this same Zoom ID, and notice will be mailed to you at the address we have on record, okay?
Thank you, I appreciate your time.
Have a good, no worry, have a good day, Ms. Morris. Thank you for your patience.
Okay.
This is 2403523 LT Trilogy versus Anita Strode.
Good afternoon, Your Honor. Ali Risk on behalf of plaintiff.
Anita Strode is here. Thank you.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. The parties have spoken. How are we proceeding?
Your Honor, at this time, we've reached an agreement that I will submit later in the form of a conditional dismissal. I can state the terms if you are ready, Your Honor.
Yes, sir.
So as of today, there is currently a total of $3,273.52. And that includes the court costs. The terms of the conditional dismissal is that Ms. Strode will make payment on July 19th for the amount I just stated, as well as any other money that becomes due and owed by that date, including but not limited to rent, utilities, and late fees.
Ms. Strode, was that your understanding?
Yes, ma'am, it is.
Ma'am, what's the status of your application for assistance with DHS?
They did approve, however, my apartment complex Trilogy does not accept payments from DHS. So
I don't understand what that means, does not accept payment when when
they
they have a
they do
non-payment
not,
case pending.
yes, they do not accept DHS payment.
Your Honor, so based on my knowledge, Trilogy, that's correct. They do not accept payments from DHS for any tenants based on multiple issues they've had with them in the past, including, well, I don't need to get into that, but essentially that's my understanding.
Here's the issue, Mr. Risk. If your client files a non-payment or authorizes you to file a non-payment case on their behalf, and there is an agency who's willing to make payment to satisfy the past due rent, and your client refuses to accept the payment, that suggests to the court that your client's willing to waive that portion of what's due and owing to them. I don't understand.
Your Honor,
If there's a, Mr. Risk, let me just say this part out loud. If there is a conditional dismissal that she will pay this $3273.52 by July 19th and include any other amounts that are due pursuant to the lease, if that's firmly in place, would your client then provide whatever they need to provide to have the funds that have been approved released to them? Their position's protected in terms of the amount due.
Your Honor, I may be wrong here, but I believe that DHS, there are additional requirements for them to issue payments that require separate agreements with the landlord. I could be mistaken, but and as well, there have been instances in the past where DHS stated they would pay and then later rescinded that promise. So I think just based on overall bad experience that, you know, they specifically don't accept payments for DHS from any tenant, and they would not be willing to waive the money that they would present either.
Ms. Strode, was Mr. Risk's statement of your agreement regarding the conditional dismissal correct?
If you could repeat that again, so that as far as conditional, so I could make sure I understand.
The document's a conditional dismissal that will indicate that you will pay a total of $3,273.52 on or before July 19th, along with any other amounts that come due pursuant to the terms to the lease that you have with Trilogy.
Yes.
And that's your understanding and agreement?
It is my understanding and agreement.
And ma'am, you were present back on June the 5th when the video played that explained the rights you have available in this landlord-tenant matter.
Yes, ma'am. Yes, Your Honor.
Do you have any questions about those rights?
I don't have any questions at this time.
Do you have any questions about the conditional dismissal?
No questions. No questions, Your Honor.
Then Mr. Risk's office will prepare that conditional dismissal, file it with the court, and as long as the numbers are what he just placed on the record, the court will sign it, and a copy will be mailed to you at the address we have on record. That's period. That's the end of that proceeding. But Ms. Strode, what I was saying to Mr. Risk is if someone files a non-payment of rent case, and this court then enters a document that secures the amount of money that's due to them, that being the $3,273.52. If you have from DHS that they have approved you for a certain amount of money, and Trilogy needs only to do a thing, a W-9 or something, I don't remember what they need to submit, but Trilogy won't submit it, this court does not look favorably upon their request for payment. If it is, as Mr. Risk indicates, that there's an outside separate additional agreement that Trilogy would have to sign with DHS, that's something more. But if it's just a matter of a simple identifying document, federal ID number, something to that extent that Trilogy needs to file to have the funds released, that's something different. That's just so the record's clear, so Mr. Risk can relay it to his client. But ma'am, was there anything else this morning?
That is it. Now, is there, from what you just said, is there anything that I need to go back to DHS to say? Because she called me personally and called me and said they will not accept. So is there anything that I need to do as far as that is concerned?
Ma'am, I don't know if the signed entered conditional dismissal would be sufficient for DHS. I don't know what it is they said to you about what they need to get the money released. How much money were you approved for?
They were going to give me $400, which is their maximum.
Okay. The conditional dismissal might be of assistance, but I would suggest you speak directly to or communicate directly to the person you've talked to from DHS regarding this matter, okay?
So,
Yes,
Your Honor, if I may say one more thing, I will definitely follow up with that. I will relay that message over to my client. That date, that July 19th date was the date that Ms. Strode provided me. I just want to make it clear. I don't make it a habit to try to pressure any tenant into entering any sort of agreement. And I did work that day on my client that Ms. Strode provided me. So I was the one pushing for that day with my client, but I will definitely follow up with my client regarding this DHS situation and see exactly what is required in regard for that payment to be released.
I understand and I appreciate your position, Mr. Risk. Thank you very much. Ms. Strode, that concludes this matter. You're free to go. Mr. Risk, you have a good
Thank you.
afternoon. I hope you feel better.
Thank you, Your Honor. You and your staff have a wonderful afternoon. Take care.
Thank you. And Mr. Nykel, Mr. Austin, and Mr. DePietro, we are back on the record in 2400518 GZ, and there's nothing else on this court's docket. So let's resume the testimony of Ms. Welch regarding the tow.
Okay, Your Honor, I'm back live.
Yes, sir.
See Mr.
As am I, Your Honor.
It's on too. Oh, yeah. Okay.
We need Mr. Austin.
I'm here.
Oh, yep, there he is.
Oh, hi, Jim. I didn't see you.
So
I'm sorry, Mr. Nykel, had you finished with your questions for Ms. Welch?
No, I didn't.
Thank you. You had to ask your client something.
Yes, I did. I just wanted some clarification. On the Ms. Welch, the impound slips or supplemental reports that you have before you, the date of January 4th, 2024, time of 12:38 p.m.
Yes.
That was the time when, in fact, the police arrived. Is that accurate for the Ford F-450 record?
Correct.
And then also the time, same date, time of 12:28 p.m. was the time when the police arrived regarding the 97 Peterbilt tractor, correct?
Let me just verify. One moment, please.
Where did you get all this information? How do you know all this?
Yeah, I know how to open this. Yeah, right there.
Mr. Day, I'm not sure that one of your client's comments being broadcast. Not Mr. Day, Mr. DePietro.
I'm sorry, Judge.
You were talking to someone and their responses to you were being broadcast, and I just wanted to be sure that you were aware that I could hear you.
I'm sorry, Judge. I'm going to mute me.
No worries.
Okay, Mr. Nykel, it looks like the police were on our lot at 12:28 p.m. on January the 4th of 24.
Is there any record you have that shows the time? We've already established that Best called you at 10:31, I believe. for the tow. What record do you have that shows when the police were contacted by you, by the record driver, I suppose? Who was the record driver?
There were 3 separate drivers.
Oh.
It looks like, let me just take a look, one moment. So it looks like he was en route.
Who?
The driver looks like he was en route to the call. Dispatch time at 10:31 a.m. Or he was on the scene at 10:31 a.m. My apologies. Hold on. I'm just gonna look through the history of my call so I can give you more accurate answers. So I can tell you that from what I'm seeing in my screen, it looks like our driver got here with the unit at 12:12 p.m. January 4th, and the police arrived shortly after. But unfortunately, it was created at 10:28. At 10:31, it was updated. And then it goes to 11:47, and then 12:11, and then 12:12. And then I completed the call at 12:49 p.m.
That time that you've given, was that the first tow to arrive at 12:12, I think you said?
So I'm sorry, you're asking if that was the first truck to get to
Well,
our
there were
property?
4 trucks, so which one was the first one that came?
So there were 3 separate drivers on this.
Okay.
So honestly, I can't tell you exactly which one showed up first because unfortunately, the system isn't updated exactly on time. I'm getting better at that. I've been kind of thrown into this position 2 weeks prior to this happening.
Mm-hmm.
So I wasn't updating the calls as I should have been, unfortunately.
So the record that I referred to you to look at was Exhibit 15, and it's shows on my screen or your screen right now. It should. Can you see at the top where it says origin phone? And you see that?
Sure, I can only see you.
Oh, you can't see the sharing. Says I'm screen sharing.
It is screen shared, Mr. Nykel. What are you asking,
Oh,
sir?
okay. I'm sorry. Then she can't see the exhibit. Is that what you're saying, ma'am? You don't see the
Yes,
exhibit,
sir.
so I can.
I only see you.
I see. Interesting. All right. Well, I guess I'll have to address this in rebuttal, Your Honor. I have no further questions of this witness.
Thank you. Mr. Austin, do you have any redirect for Ms. Welch?
No, Your Honor.
Thank you. Ms. Welch, thank you for your testimony.
You're welcome. Thank you. Am I all set?
Unless Mr. Austin wants you to stay available but muted.
Val, I'll let you know if we need you. You can be done.
Okay, thank you.
Thank you.
Thank you. Mr. Austin, any other witnesses?
That's all I have, Your Honor.
Thank you. Mr. DePietro.
Muted.
You're muted, sir, but if you're ready with your first witness.
No, I'd like to make some offers first, Judge.
Absolutely.
My offers essentially come from the exhibits filed by Mr. Austin's client. And that exhibit that I'm interested in offering now is the one of the sign. I believe that's exhibit 3 on Mr. Austin's brief. I'm offering that into evidence. It's a sign on my client's property relative to unauthorized people will be towed. That sign is required by statute. And what exhibit is that? It's Jim's exhibit 3, which I
Give me
adopt.
one moment, Mr. DePietro. I'm looking at
I have it on my screen, Your Honor, if you'd like to.
the brief in support filed by J&M Towing on June the 18th. Okay. Number 3, thank you, Mr. Nykel. Is that what you're referring to, Mr. DePietro?
Yes, Mr. Nykel has it on his screen.
Yes, sir.
I offer it.
Any objection, Mr. Austin?
No objection.
Any objection, Mr. Nykel?
Well, Your Honor, I'm going to, in rebuttal, address this sign. But and or in the case in chief, I guess it is what it is. I'm not sure how, I mean, I guess I would object to it because I don't believe it was ever up when on January 4th. I think it's after the fact. I don't know when the time was that this photo was taken. I don't know who the photographer was. There's been no foundation, so objected.
Mr. Nykel, having objected, Mr. DePietro, how do you intend to proceed?
My offer stands. I mean, it's there. Mr. Austin hasn't objected. Unless he's got a serious challenge to the sign, the picture, I don't see it. His objection should be sustained. He said he doesn't know when it was up, and et cetera. I mean, it's.
My client's going to testify that that was not present at any time until the first time it's ever been seen is with this exhibit. And
I thought
don't know who took it, don't know when it was put up, for what purpose is it being used, other than to show compliance with the statute, which, Your Honor, I believe the best concrete cement, best asphalt did not comply with that, because on the time, the January 4th, it did not exist on that property.
This judge, that is there testimony? I thought he rested with regard to Mr. Creasy. Well, there's nothing to rebut if it's not admitted. So I guess we need a ruling, Judge.
Okay.
You withdrawing your offer, Mr. DePietro?
No.
Okay. So the offers that the court received as an exhibit, defendant number 1's exhibit number 3 as attached to his brief that was filed on June the 18th, if my understanding is correct.
That is the document, Your Honor, yes.
It is received over objection.
Thank you, Your Honor.
Thank you, Your Honor.
Now, Judge, I had this morning at 8:18 a.m., I received some new exhibits from Mr. Nykel. that I had not seen before, and they were testified to on the record. For example, one was his Exhibit 25 relative to preferred leasing. And Mr. Papazian's testimony that he owned it and it's a valid entity, et cetera. I have, which I obtained in a break, a document from the state of Michigan, which shows that it was dissolved on July 15th, 2010. So whatever weight he was attempting to give to the vitality or viability of that corporation and his relationship to it ceased to exist, according to this record, in 2010. And I would offer that as a plaintiff too. Unfortunately, because I just got it, all I can do is show it to you. I don't know how to do a split screen. Can I do a split screen from?
I'm listening to you, Mr. DePietro. You have it in paper form, but you don't have it on a computer screen. Is that what you're saying?
Yeah, Judge, I just pulled it off of the website. If I hit split screen, can I show it or something, or?
If you, at the bottom where it says share screen,
Yes, Your Honor.
if you hit that, it will come up.
Okay. No, see it coming up, Judge. I guess I could email it in or something. I don't know.
If Mr. DePietro, if what you're saying is that you have searched on Lara regarding Preferred Leasing Inc. and the corporation was dissolved in 2010?
July 15, 2010.
And that's pertinent to our hearing.
Yes, Mr. Papazian was contending that he was the owner of a corporation or had an ownership interest in the corporation. I don't remember, Judge, if his testimony pertained to the fact that he was shown as an owner on his title or whether he was I really don't recall at this time, other than he was vouching for the validity of that court. And in fact, we admitted that document, I believe. But I could, I guess I could email him or something.
Let's reserve on that issue, Mr. DePietro. Was there something else?
Yeah, they had another one for Nuts and Bolts LLC. Now they turned out to be an owner of one of these relevant vehicles. And that document also shows that it was dissolved. I believe that was his Exhibit 25. And again, I just got it this morning and in and out of these hearings because I didn't receive them until I was alerted that they were in my mailbox at 8:18 a.m.
It was exhibit number 24. And Mr. DePietro, when the court first called the case, yourself and Mr. Austin got into a breakout room and missed me indicating to Mr. Nykel that the court received the filing at 3:51 p.m. yesterday. So I saw it this morning as well.
Yes,
the
I
nuts and bolts,
I have no reason to doubt that, but the service time was 8:18 this morning. And I did not check my email. I was doing client prep at the time. And then the count,
understood. And I appreciate the position, but I'm sorry, Mr. DePietro, I'm interrupting you because you were saying that you have since looked up something regarding nuts and bolts that you wanted to highlight.
yeah, that it's dissolved or not in good standing, excuse me.
Your Honor, both of those entities were entities, well, certainly preferred leasing had to do with, they were a titled owner on one of the Kenworths that Your Honor is not addressing today in this petition. Nuts and bolts, however, irrespective of whether it was in good standing or not, is the title holder, and it's the entity that Mr. Papazian had titled that property in. If it was later dissolved, it wasn't dissolved, it may or not be in good standing. That's possible, but I don't think that's relevant to this. Since the title is in hand and the property was redeemed, and now this is the question of whether it was properly deemed abandoned by the owner or whether the towing fees and storage are appropriate.
Well, it certainly goes to the question of his ability to perform legal actions on behalf of the corporation. And he didn't get notice, he claims personally, because his lien holder had to get it because he wasn't on the title. Nuts and bolts was. So if someone looked up nuts and bolts, they would find out that that corporation wasn't in good standing, still raising the issue of whether this was the proper owner or not. I'm just trying to rebut the fact that they left you with the impression they were in good standing and they're not.
Next, Mr. DePietro.
Say again, Judge?
I said, what's next, sir?
Did we get a ruling on that?
I think that Mr. Nykel has indicated that it may not be in good standing, but it had not been dissolved. And your screen sharing is working now, Mr. DePietro. Are you trying to show something?
Well, I mean, we were told that these were viable corporations by implication and that he was a part owner of them. And according to the state of Michigan, he hasn't performed what's necessary to keep the corporation in good standing. He's got 31 of these out there. And I know you don't want to hear about it, but it's a question in my mind as to the bona fideness of using corporations. And I think that's evidence of how he treats them, which is consistent with my contention that they're just shells.
They're not shells, Your Honor, because
Understood, sir.
property owned. Certainly a title.
I'm sorry, Mr. Nykel.
I'm sorry, Your Honor, I'm just saying it can't be a shell if it owns assets. And, it's certainly in this case, those assets are owned by those entities. And nobody but Mr. Papazian stands for those entities, irrespective of whether they were in good standing with the state of Michigan. And it was certainly satisfactory to J&M and the Secretary of State at this point to have, with respect to the petition and the posting of the redemption of those properties.
Judge, there's no showing on the notices under the statute that Nuts and Bolts got any notice relative to Mr. Papazian's ownership. I mean, if he got notice, the nuts and bolts. Why did he have to wait on, Randall Ferguson to come and tell him he got notice?
Your Honor, I think this is just delusion, and I don't know, I really don't see. I mean, there's been testimony by Mr. Papazian that he didn't get those. Now, whether the address was incorrect, whether the Secretary of State didn't mail it to Nuts and Bolts, those are questions that aren't clear. We don't know. All we know is that those titles are in those names. Mr. Papazian is the principal and or member and or corporate stockholder of those entities.
Mr. DePietro.
I have no further statement, in support of my office.
Thank you. Is there a witness that you're calling, Mr. DePietro?
No, Your Honor.
Thank you. Mr. Nyko, is there anything else, sir?
Well, I'd just like to rebut two matters. Or are you talking about, no, well, Mr. DePietro didn't have any witnesses. So are we back to rebuttal then for what Mr. DePietro has presented?
Judge, may I interject just for a second? Is Mr. Chantel, Mr. Nichols?
Sims.
He is. I see him out there.
Yeah.
Might be a nice time to talk to him. I don't know, Your Honor, whatever you think.
Well, we've already gone through. Mr. Nykel rested. Mr. Austin put on his one witness. You've made 3 offers, one regarding a document that the court received as part of defendant number 1's filings. The second issue was the dissolution of preferred leasing, which I believe Mr. Nykel acquiesced to that being the state of affairs as it relates to the Lara filings, what that means in terms of Mr. Papazian operating that business, although it's not good standing or dissolved with the state, that's an aside. Same with the nuts and bolts issue, that it's not in good standing with the state, but the indication and the implication is that Mr. Papazian continues to operate nuts and bolts even with the not in good standing status. So if Mr. Nykel feels as if he needs to respond further to the corporation issues, we'll take it up, but unless there's something that is earth-shattering to be uncovered and rebutting, the issue is and has been the vehicles being deemed abandoned and the reasonableness of the tow amounts and the storage fees. So that's where we are. Mr. DePietro, you've already indicated you have nothing further. Mr. Austin indicates nothing further. So this is the court's rebuttal from Mr. Nykel.
And Your Honor, you had indicated though that you would hear from Mr. Sims, you know, that I was under the impression that once he was able to dial in that you would hear testimony from him. I guess
Nothing's changed.
rested.
No, nothing's changed.
Okay. So we may call Chantel Sims.
Mr. Sims, would you unmute yourself, state your first and last name for the record, and spell them both?
Chantel Sims, CHONTELLSIMS.
Mr. Sims, do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Nykel, please proceed.
Hi, Mr. Sims. Thank you for diligently getting back on after being off a couple times and back on a couple times.
Yeah.
I'm going to call your attention to activities of December 18th, 2024. Were you called to move any truck tractors from a location at Best Asphalt?
Yes.
And who contacted you and contracted with you to move those vehicles?
It was, I believe, Paul at American Crosstalk Industry.
And okay, thank you. And did you show up at the Best storage lot on that date?
Let me check back, see what date that was that I. Yeah, yes, it was December 18th, yes.
And were you able to tow any vehicles from the lot?
I towed 2 vehicles.
Which vehicles do you have records to show which vehicles were towed?
It was a 95 Ford tractor and a Peterbilt 359. I have license plate, wasn't able to get a VIN number off of it. The Ford tractor, I have a VIN number.
Were you able to, were there other vehicles that were believed to be to part of that tow bill or tow
There
dispatch?
was, I believe originally there was a total of 6, but 4 were not towable. When I spoke to the customer about towing the vehicles, they were to be made towable, so I did not have to deal with any flat tires or removal of any driveline components or anything like that.
What do you have to do when there's flat tires? Does that change everything?
Either get them aired up if the tire is not seating on the rim, possibly have to take the tire off the vehicle to get the tires aired up and put back on the rim. And within the tow truck, I don't carry all the tools necessary to do that.
Was anybody else there that met with you at where the vehicles were located at the Best Lot?
2 gentlemen introduced themselves as the owner and his son of Best Asphalt, or the property there, located the property location. They took me to where the vehicles were parked.
And you left those 4 vehicles behind was there an understanding as to what you were going to be doing? Were you going to be back?
Yes, the customer was supposed to let me know once there's also a shop there within the vicinity of on the property that was going to make the vehicles so they roll and towable. And then once they got the tires aired up so they roll and everything, they would call me back and let me know when to come back and get the other 4 vehicles.
There was a shop there on the Best Lot?
There's that all property. There's it's a whole complex, and there's buildings at the front of at the entrance to the property, to the Best Asphalt. I don't know if it's still the same. I don't know if it's owned by the same property owner, but there's a repair shop, a truck repair shop, I was told, that would get the tires aired up, make the vehicles towable.
Who told you that?
I believe it was Paul.
Okay. Paul Papazian, is that who you're referring to? Not someone from Best Asphalt.
No.
Okay. Did you go back to the property to pick up those 4 vehicles or any vehicles, or attempt to at any point?
I contacted them, the customer. I believe I contacted them. They were supposed to let me know when it was ready to be when the rest were ready to be towed. And nothing was that. When I did contact them again, they told me the vehicles have been towed, but I don't remember the dates exactly. I'd have to go back through and check texts or see if I have phone records of when I contacted them again. But nobody had contacted me to let me know.
All right. I have no further questions for this witness.
All right.
Thank you. Mr. Austin,
Nothing, Your Honor.
Mr. DePietro.
Yes, Your Honor. Thank you. Hi, Mr. Sims. My name's Tom DePietro. I'm an attorney for Best Asphalt. Appreciate you being here today.
No problem.
Do you have records of what you told?
I have, it was a 95 Ford tractor and a Peterbilt 359 tractor.
Do you have VINs?
I'm sorry.
Do you have VINs?
I have a VIN number for the 95 Ford tractor. The VIN number on the Peterbilt 359 must not have been legible because I just have a license plate number that's on it.
When you say not legible, what do you mean by that?
where a lot of times with trucks, the VIN plate is right on the pillar where the door latches, and usually drivers rub it against it and so on and so forth. It gets rubbed to where you can't read it.
Okay. What license, did you have a plate number, did you say?
The license plate number was Apple Charlie 10010 on the Peterbilt 359, and then the 95 Ford Tractor. I have a VIN number.
And what is the VIN, sir?
1 Frank Tom Yellow Robert 828 Sam Yellow Alpha 59934.
Okay, 1 Frank, Tom, Yellow, Robert, 828, Sam, Yellow, Apple, 59934.
Correct.
And did you have any idea of what the identity of the other vehicles that were on the lot that was being discussed with your client, Mr. Papazian?
I didn't record what it was. I know there was a Ford tow truck, like a flatbed wrecker. I believe there was a Peterbilt tractor, if I'm not mistaken, but I don't recall exactly what the other vehicles were.
Okay. And did you inspect those vehicles?
Yes.
And did they have tires on them?
They had tires on them, yes.
Did you happen to notice whether there were engines in them?
That I don't recall.
And then, as I understand it, Paul was supposed to get back to you with a new date to pull the vehicles. Once he got them aired up.
Yes.
And you never heard from him?
No.
Excuse me just for a second, sir.
All right.
Thank you, Mr. Sims. I have no further questions.
All right.
Mr.
Thank
Sims,
you.
I'm sorry. I'm ready for Ross. Unless Mr. Austin wants to go.
Still nothing from me.
I was coming back to you, Mr. Nyepel.
Thank you. Mr. Sims, do you recall reaching out to Mr. Papazian by phone to inquire about the status of the tows that had not been done at any point after January or December 18th?
I'm trying to remember. I think that when I finally did, because I hadn't heard from anybody, and there was an open invoice, so I hadn't been paid on the work that I had done. So I don't have the phone records or times or dates when I called them back, but I had no idea to call them back because I wanted to get at least paid for what I had done if they weren't going to move the rest of them. And when I did reach out to them, I think they told me that the others had been impounded.
So that was after January 4th then, or
yes, I want to say we got through. I want to say we went through the holidays and everything, and I said I couldn't tell you exactly what date I reached back out to him.
All right.
I know I did because I hadn't heard from him.
Okay. That's all I have for Mr. Sims. I thank you, Mr. Sims.
Right.
Thank you for your testimony, Mr. Sims. You're free to go. You have a great day.
Thank you, sir.
Any closing, Mr. Nyepel?
Your Honor, may we go back to that Exhibit 3 sign, and I could possibly rebut Mr. Pietro's? I don't know if Your Honor even accepted those. Did you accept that?
I accepted number 3 as having been attached over. I accepted number 3 over your objection as having been attached to Mr. Austin's brief. As for the other 2 proffers made by Mr. DePietro, they are state of Michigan records that are easy enough to check. It was the dissolution of preferred leasing in 2010 and nuts and bolts not being in good standing since 2020, or I'm sorry, 2021. So they weren't actually exhibits, there was information. And if you're by rebuttal, you mean either that's not what the law records show, or you have something to show that those business preferred has not been dissolved and nuts and bolts is in good standing. That would be the only rebuttal, but those are not exhibits received per se. That's more information.
Your Honor, I was hoping to rebut with respect to Mr. Austin's witness, J&M, about information that was as to the dispatch, the timing, and whether or not the police were actually called before the tow or if it occurred after. And I would like to address that because I've got a report that indicates the timing. And apparently that witness wasn't able to, she raised the issue, opened the door about this question of timing, but had no records. And I would like to go back to an exhibit that we had actually not asked for admission, but had provided to the court and marked. So I would like to be able to address that as well as the sign with Mr.
Okay, would the sign change any argument you would make regarding the vehicle being deemed abandoned or the reasonableness of the fees assessed by J&M Towing?
Well, I think the statute requires that the tow yard, or rather the best property owner, personal property, private property owner, is required to have such a placard or sign. And in the absence of it, then they've not complied with the statute. So yes, it does have a bearing.
Well, if Mr. Austin filed, sorry, Mr. Austin, was there some response you wanted to make regarding the sign in your exhibit?
There's nothing I had to say. I mean, that has nothing to do with being the private property owner. I think that would be Mr. DePietro's, not the towing company's. Towing company comes at the behest of the property owner.
I asked only because it was a exhibit to your brief.
Yes, I borrowed it.
I have, it can come or it can go, Your Honor. I don't care.
Thank you. Mr. DePietro.
Yeah, Judge, I don't have anything to offer. I mean, I admit I borrowed his exhibit because I didn't have a copy and I didn't know how to get it to you anyway. In any event, I guess Mr. Nykel wants to rebut it somehow. I don't know how he's going to do with it. He's trying in Armenia and in a hospital and everything, but whatever.
Well, and I can also, under an adverse witness, I could call Mr. Stefanko to ask him questions about the presence of the sign, but I don't know how reliable that would be. And given that my client is informed me that he's never saw that sign and that it's new since January 4th, 2024, and that, so there's that issue.
Judge, the client's already testified that he was out of town. And then he didn't get back till the 9th. There's no testimony that he was ever at the scene at any time. Even Mr. Sims didn't suggest that Paul Mr. Papazian was at best. He talked to my client and his son, apparently. So,
Right, but the photo shows up in June attached to a trial brief or hearing brief by Mr. Austin that there's no foundation as to when it was taken. It may very well be there now. There's no question. I'm not doubting that. Talking about what existed on the date in question, January 4th, 2024.
But Your Honor, there's no testimony either way right now as to whether that sign was or was not there. So it's hard for Mr. Nykel to make an argument that it wasn't there because there's been no testimony that way. And similarly, there's been no testimony that it was there. So at this point, unless Mr. Nykel is going to bring someone in to talk about the sign, I think the sign issue, as far as the statute goes, is moot.
I would concur, Your Honor.
But I would say, Your Honor, that it should be, given that there is no testimony by respondents, either of them, certainly in support of their own exhibit, that it would be, the light more favorable to the petitioner for the court to take notice that there's no proof that there was a sign. And in fact, there just as well may not have been a sign. There's no proof of compliance with the statute. That's what I'm
Your
saying.
Honor, at the very least, there's been proof that a sign existed at some time, which is far more than any testimony that it wasn't there at the time.
Mr. Nykel, the court hears your argument, and again, the court has received number 3. It was attached to Mr. Austin's brief, and there's not been any the argument that, or the implication that the sign was put up specifically for litigation, the court finds difficult to believe, considering Mr. Stefanko and Best Asphalt has been in this location and clearly has other things stored on the property and operates some other business or businesses at that location. I'm accepting the sign in its entirety and without reservation. Was there something else you wanted to address before your closing?
Just well, it involves recalling my client, since I have no other way of other than to if a sign exhibit that I objected to can come in even without any foundation, maybe the court will take notice of this exhibit 15, and then I won't have to take issue with it. But exhibit 15 that I had for the court attached to my brief showed the there it is. Oh, I'm at the end of
I'm sorry, I'm just going back to number 15. Give me 1 second, Mr. Nykel.
Sure.
What is it that you want me to see on number 15, sir?
So on number 15, this is Romulus Police issued this incident report, abandoned auto. And it shows that a call was received at 10:54:53. And it showed that the police were dispatched to the yard at 11:56, looking at the top lines across, and then arrived at 12:09. Under the comments, it shows that at 10:54:53, 4 semis to be inspected that were private tows from Beverly Road, indicating that those were in fact already towed at 10:54 when the call was made. It had already been towed from the Best Yard to J&M. And the 12:22 or 12 afternoon testimony by the J&M's representative was that that was when they arrived, but it was really the police that arrived, not the, and I tried to make that clear, but she wasn't able to. She didn't really understand and couldn't articulate the times. It's trying to establish what time was called, because the statute requires that the police have to be called before the property is moved, before the tow. And that isn't the case here. It's, you know, there's no, it shows here that the call came in at 10:54 and that the property was going to be, you know, had been, it had to be inspected, were private tows from Beverly Road. In this incident report shows that it was, that the property was now at J&M. And so I want to show that the phone call to the police was after the fact, after they'd already been towed from Beverly Road to J&M. Then the call was made.
Correct me if I'm wrong, then, Mr. Nykel, Mr. Austin, or Mr. DePietro. The testimony was that Best Asphalt called J&M at 10:31 for these tows off of private property, that the driver called Romulus PD at 10:54. Mr. Austin's brief indicates that Romulus Police indicated to J&M that they were tied up and they will come to the yard to do the tow slip information. And that thereafter, the driver arrived at the Best yard, I'm sorry, at the J&M yard at 12:12 p.m. And Ms. Welch's testimony was that she couldn't say which truck came in first because there were 3 drivers out there. Her records didn't indicate which of those 3 came first, and that the police arrived on the scene subsequent. At that time would be in the dispatch log that you attached to your brief filed last night or this morning, served this morning, whatever the sequence is. Is that the timing?
Well, I think
That's the timing as far as my client's concerned.
But the exhibit 12 shows, or 15 shows that that wasn't the time.
Your Honor, I would object to this because number one, we can barely read it. Number two, while Mr. Nykel is doing a great job of interpreting it the way he wants to interpret it, I think we would need someone from the Romulus Police Department to actually say what each of these things means and what happened, rather than taking Mr. Nykel and the document as it is. I don't know what those mean. I don't know whether that means this is when things happened after the phone call that they initially made and said and told Romulus PD told J&M, we can't do it right now, take them and we'll do it later. There's an awful lot of questions to just have this come in the way that Mr. Nykel wants it.
Understood, and the court concurs with you, Mr. Austin.
Thank you, Your Honor. I guess we're prepared for closing. Your Honor is ready.
I'm ready, sir.
Okay, thank you. I believe the testimony has been presented to the court by Mr. Papazian that shows that as I had stated in the opening, that that the complete diesel repair brought the vehicles, 8 vehicles, they were towed to J&M. The tow receipt that was admitted was Exhibit 1. And it shows that there was the testimony was that there was no actual written lease, but there was a verbal understanding between the parties. Best through Mr. Stefanko, and complete diesel repair through Mr. Papazian, that these that there was a lease agreement. That there was and that first payment was on the 10th of the month. It was actually November of 2020. And payments had all been made throughout that period of time until January 4th, 2024, when Best chose to determine that these were abandoned vehicles and to be impounded, even though there was a lease, certainly a lease agreement de facto that was established between the parties. Yes, there was effort to remove vehicles. 2 of them were removed on December 18th. And that was going to be a process because, you know, as fate would have it, the holidays came upon everyone. My client, Mr. Papazian, had travel plans, left the country, and could not address trying to get those vehicles serviced so that they could be towed by Mr. Sims, who testified that he had come on the 18th of December, that he removed 2 vehicles, that 4 remained, and that Mr. Stefanko and his son were well aware that the challenges that existed with respect to the condition of those 4 vehicles, and really that is more goes to the issue of why they weren't towed at that time. But the fact of the matter remains, Your Honor, that those vehicles were still, there was still lease space paid for in that lot at Best Asphalt on January 4th, 2024, when they were removed. So, you know, you look at the statute and you say, okay, does everything, just because it gets towed, fall under the statute? Well, it talks about what constitutes 257.252A. 2A shows, you know, 2 and A. 2 says the definition of an abandoned vehicle means a vehicle that has remained on private property without the consent of the owner. Well, the consent of the owner was given because there was a lease. They were within the term of the lease. And Mr. Stefanko and Best Asphalt had no right to, at that point, invoke the statutory process of the abandoned impound vehicle statute. Having done so, it basically violated Mr. Papazian's rights and the rights of Complete Diesel Repair to have that space that had been contracted for. Payment was on the 10th, so therefore payment wouldn't be due till it would be due on the 10th. You know, payment originally came in on the 10th. Wasn't a first of the month kind of an arrangement because there was no proration of the payment of the first payment, having it paid only from the 10th because $1,100, it was testified to by Mr. Papazian, $1,100 was the rent. That's what he paid on sometime between the 10th and the 14th of January of 2020. And so he was, and he was out of the country, couldn't do anything about it. But he also didn't even he gets a text from Mr. Stefanko, you know, before the holidays saying, what are you doing for the holidays? Well, my client tells him, I'm going to be visiting home. You know, I'm going back to Armenia, visit family. Well, what was the reason for that? Who knows? We can't speculate about it, but is it just by strange coincidence then that on January 4th, while my client, to the knowledge of Mr. Stefanko, is out of town, tows these vehicles. And then, of course, to add further injury to it, he's doesn't even get the notice other than through Randall Ferguson, who is a lien holder of one of the vehicles. Why that is the case, we don't fully know. We don't know why the state of Michigan didn't send notice, or why Nuts and Bolts didn't receive, or even Paul Papazian, the other owner. There was no notice received. And so immediately he proceeds to go and redeem on the I believe it was the 18th of January, or the 24th rather of January, where he redeemed the properties, at least two of them. But he was not able to do anything because about the other two vehicles, because of an investigation underfoot that Romulus Police had started by turning the matter over to the car, the auto theft CATS, it's called, system. And they didn't close that until May. But my client went routinely. He kept going to the police department. It was going weekly to the police department, and just kept coming up with nothing until finally in May those released. So my client couldn't even at that point had considerable storage expenses attached, 24,000 plus in total.
Your Honor, we're back on the other two vehicles again. I know it's closing argument, but we're talking about the two vehicles that you specifically said long ago. We're not talking about those.
Your Honor, understood, Mr. Austin.
I'm sorry, Your Honor.
You're fine, Mr. Nykel. Proceed.
Okay, thank you. At any rate, because it's almost like the fruit of the poisonous tree, in that, you know, the statute was invoked and wrongly from the get-go. And so anything that comes afterwards shouldn't be allowed. You know, court should find that all the vehicles were improperly towed, that they had a right to be on that property at least until the 9th of January, or when the time period was up when rent was due or the lease payments were due. And of course, without notice given, my client had no way of knowing that this was happening. He comes back the 6th and 7th, actually landed on the 6th and came back to work on the 7th. Just kept working, didn't know anything about it. And then Randall Ferguson gets notice and sends it to him, and he acted promptly as a result. And he didn't intend to abandon any of his property. He intended to continue to pay his rent until he was able to now address it, get those vehicles properly ready for tow, so that Mr. Sims could move them. Was not allowed to have that happen. Your Honor, we ask that court finds the party that has been violating, that did not follow the law properly, did not follow the MCL 252A, and at SEC properly that those were not abandoned vehicles. So they don't fall within the purview of the statute, and therefore all costs and expenses incurred by my client should be reimbursed to him by Best Asphalt and or J&M Towing, or both. Certainly the agreement, was with Best Asphalt. So clearly that would be the perhaps the more appropriate party to be surcharged for this. With respect to attorney fees, because I don't think that the statute allows for attorney fees, but when there's an egregious action taken by a party that violates the rights of a contract or a party to a contract, such as the lease, that there should be some compensation for attorney fees to Mr. Papazian, who's had to pay upwards of $5,000 in attorney fees. And I'd ask that attorney fees be awarded as well, if that's necessary to establish a hearing just for that portion. Ready and willing to do so. Thank you, Your Honor. We appreciate your indulgence all day. This has been a lot to this, maybe more than some would like to say should have been, but I think, my clients needed to have his day in court, and thank you for your willingness to listen and be so attentive.
You are welcome. Mr. Austin.
Your Honor, briefly, MCL 257-252A10 states in pertinent part, if a vehicle has remained on private property without the consent of the property owner, the owner of the private property may have the vehicle taken into custody as an abandoned vehicle by contacting a local towing agency. Val Welch testified that J&M was contacted by Best Asphalt as a private property owner to remove the Peterbilt and the Ford F-450 from their property because they were on the property without the consent of the owner. So they fulfilled MCL 257-25A10 was fulfilled. 257-252-11 states in pertinent part, before removing the vehicle from private property, the towing agency shall provide notice by telephone or otherwise to a police agency having jurisdiction over the vehicle that the vehicle is being removed. Again, Val Welch testified that when they got to the property, they contacted Romulus Police. Romulus Police were not able to take the information at that time and said, go ahead, take them to J&M Towing. We'll send a unit over. And they did so, and the impound cards show that. And the testimony backs it up, nothing to refute that was not followed as well. Those are the two things that J&M had to do under the contract, and then store them safely and securely. And they did that. And that's until the vehicles are redeemed or a hearing is requested. So as far as process goes, everything was done properly by J&M Towing. As to the towing and storage fees, Val Welch was again asked whether the towing and storage fees were commensurate with those of towing companies in the area. And she said, yes, they were. There was no evidence to the contrary to show that any fee was not reasonable, except for Mr. Papazian saying that he thought they were exorbitant. And I asked him if he had any reference for that, and he said no. So there are two reasons that you can bring the towing company in to a petition like that. One is that they didn't follow the process. They did follow the process. Two, that the fees are unreasonable, and they weren't unreasonable because there's been no testimony to show that they were unreasonable. So J&M shouldn't even be here. This is a problem between Mr. Papazian and Best Asphalt. But as far as the statute goes, as far as J&M goes, everything was done according to Hoyle. And because of that, if I look at MCL 257.252A16, it says in pertinent part, if the court finds after a hearing on the reasonableness of towing fees and daily storage fees that the owners or secured parties' challenge was frivolous, the court shall award to the custodian costs, including reasonable attorney fees, against the owner or secured party. Because there's been no evidence that J&M did anything wrong or that the fees were unreasonable, we'd request the reasonable attorney fees be awarded to J&M. And that's all I have. Thank you.
What's reasonable, Mr. Austin?
Well, I would say for today between, we'll call it 9 and 2 o'clock at $2.50 an hour. That's just for today's. That's my $2.50 an hour is my going rate.
Mr. DePietro?
Judge, Mr. Austin's request is news to me. There was no notice that he was requesting attorney fees. I'm not sure he's saying that those fees should be assessed against the owner when the owner of the vehicle redeemed the property. Mr. Austin is stuck in this case through no fault of Best. Mr. Michael could have released J&M from this case and pursued the Romulus PD and Best, but he dragged them along in the hopes that he can get them to cut their fee, cut the storage fee, and pay some money. In any event, this comes as a shock to me. We certainly didn't invite J&M Towing into this case, Judge. We wish they weren't here, in fact. Our dispute is not with them. We are not challenging their fees. We're not challenging anything they did. And, you know, I'd asked for a stip to release them. I would have done it on day one, but I suspect my co-counsel would have objected to that. Getting back to Mr. Nykel, I'm not aware of any authority that says a court has the authority to award attorney fees because someone took an egregious action in litigation. In fact, I don't think I've ever been involved in litigation where it wasn't alleged that somebody did take egregious action. That's why the American rule is followed very tightly by our jurisdiction. And there's only some exceptions to the awarding of attorney fees. Violating a court order, filing a frivolous action. By the way, we filed nothing in this case, Judge. We've just been trying to get involved and resolve it. Contract. This alleged contract that existed and made no provision for attorney fees. And there is literally no way to collect attorney fees absent those features. Now, getting back to the amount of money involved, Mr. Papazian was a perfect litigant in this case. He did absolutely nothing wrong, according to Mr. Nykel, other than having 31 corporations doing various parts of his business, none of whom were shown to be, or I should say, had an address that the Secretary of State could utilize. It was preferred leasing, and it was Mr. Ferguson had to get the notice because there was no place else to go. And part of Mr. Papazian's diversions was he didn't want to talk about Mr. Ferguson or these alleged liens. It was none of my business, he said. Well, I didn't get into it too much further than that because the court was quite clear on that. But to me, Judge, it was obvious that he was dodging the facts. He was attempting to change his testimony. He makes a representation to the court. I got notice on January 10th. There's nothing about Ferguson. There's nothing about him walking in. There's nothing about that. I got notice on January 10th. Now, he knew ahead of time that I was going to inquire on that because it was my position. He should have acted much sooner than 14 days later. And, you know, he can sit on it and just figure that somebody else will pay for his latches or for his comparative negligence or for the percentage his own actions contributed to his own loss. And I would say in regards to the other two vehicles, they are informative only from the fact that the guy waited 5 months to do anything on those. He followed a pattern. He knew, according to his own witness, that he had to be out of them premises in December. He knew that he had paid December's rent and there wasn't anything more that he was going to get out of my client. So he sends these guys over to pull the thing in December. And then what does he do to the tow truck guy? Never talks to him again. It's the same thing. I had to go out of town. None of your business. Somebody else got the notice. I didn't get the notice. And it's pretty obvious to me, Judge, that he's just sitting back trying to get some money by virtue of his own latches. So the statute, as pointed out by counsel, is clear that if you don't have the authority to be on the property, you're subject to towing at your own expense. And those are the facts. He's trying to establish a due date for the rent. I don't know if you remember his testimony on it. He was all over the place. Ed's leading him left and right. I didn't say anything because I didn't think he was going to take that long doing it. But you look at his checks. They're in evidence. There isn't a check there that's made on the first of the month. They're all made in the middle of the month, at the end of the month. There's no due date. Heck, if there was one, he certainly wasn't respecting it. So to boost himself into the idea that even though he attempted to remove vehicles in December, he had no idea that those vehicles would be gone when he decided to go and take another trip abroad. Again, he's kind of like ignoring his responsibility and forgetting about the trucks that he attempted to tow, and he doesn't get back into town till he feels like it. And then all of a sudden, he finds out that they were in fact towed, just like he knew they'd be towed when he set his guy over there to pull those trucks. So he's got some responsibility here, Judge. I'm not going to, if you can argue that the police department has responsibility because of their timeliness or lack of timeliness. I'm not looking to throw everything on everybody else. This man is taking advantage of his own latches, and I believe this court needs to hold him to his own responsibility. As far as Ed's request for attorney fees, there's no foundation for that. There's been no sworn statements. Attorney fees have to be submitted if they're going to be awarded. They require a specific time, an affidavit, cost, pretty much through the taxation process if there's going to be anything awarded like attorney fees. But here again, you got to cross that bridge, and the bridge has got a big gap in it. And so I think Mr. Papazian has to pay part of his own responsibility here. Thank you, Jim.
Thank you. Mr. Nykel, anything else?
Well, Your Honor, with respect to statement in closing that the petitioner could have released J&L. Well, that never was proposed. I never heard from Mr. Austin that was something that was requested, and I think that it's kind of been, that's how this matter, the genesis of the matter was to go, initially the way the clerk of the court was testified to, when Mr. Papazian filed that he could not file the against Best, he had to file against J&M. And that was the court who added Best when we said they were a necessary party to this. So I don't think that there was anything that would have suggested that J&M certainly wasn't requested that they be removed from the case. Talking about, Mr. Ferguson and liens and 31 businesses is all kind of smoke and mirrors here. It's not relevant. And it's trying to call the court's attention away from the real focus, which is what did Best do? Did they act properly? Was the statute violated when you look at what it takes to determine what is an abandoned vehicle? Again, remained on private property without the consent of the owner. Well, just suddenly wakes up one day and says, I remove consent. I'm going to call and get it towed. That's not the way this should go in business. You have a lease, you honor your lease, you give notice that you're going to terminate the lease on a period of time that's within the period that's been paid for, usually a 30-day, if that's how payments were, a 30-day notice. Nothing was ever given. Instead, using, I don't know if I mentioned this, I may have mentioned it maybe in our meeting room, but the statute's being used by the private property owner as a sword and not a shield.
You did use that.
I didn't use it in front of the court. I used it with you so I think that's the best way I can summarize it, Your Honor, there, that the statute should not be invoked. It should not even be at play here due to those, due to the fact that there was a lease agreement. And trying to make some argument that Mr. Papazian was, trying to get some money, like shaking down someone to get money when they're responsible for a delay. Well, when you really look at the facts here, Your Honor, what you see is as a very bad actor in the form of Charles Stefanik and Best Asphalt, who has essentially used the statute the way it was not intended ever by the legislature to be used. And so therefore they should not be able to hide behind it now and say, oh, well, but the reasonable towing and storage fees. Well, that's just not the way this should work. If it doesn't meet the statutory definition of an abandoned vehicle, then everything following it should not apply in terms of the statute. And but there's been damages because of it. So the court, I'm asking the court to essentially take that into consideration and award damages to my client for this improper, for taking action that should not have been taken on January 4th, 2024. And as far as attorney fees, yes, the American rule. But I think that Your Honor has some latitude to assess costs, and at least for today, and I would join with that same number for today that Mr. Austin voiced. My hourly rate's $2.50, and then 5 hours anyway. It's 2 o'clock exactly. Started at 9, actually started at 8 at my end. But So it asks for the court to award reasonable attorney fees and costs as well. Thank you.
Thank you. The court has had the opportunity to read the briefs that were submitted by Mr. Austin and Mr. Nykel, along with all the attachments, hear the testimony of the individuals this morning and afternoon, and will make the following findings and ask Mr. Austin to submit an order that reflects this court's findings. Although the petitioner's position is that this was not the proper methodology to address the towing of the vehicles, it is the petitioner who started us down this path of petition regarding impoundment of motor vehicle. It's petitioner's position that there was a lease that existed by and between Paul Papazian and Best Asphalt, but there has not been clear information provided to establish exactly what was being stored, in what dollar amount, and what the period of time was. This court, in reviewing the exhibits that were attached by the parties, concurs with Mr. DePietro's position that the payments were made in different amounts over different periods of time. Mr. Papazian's testimony was that there was started with 8 vehicles and reduced, or 6 and reduced to 4, and the number changed over time, et cetera, et cetera. But the court's findings as relates to the petition are as follows. The court will find that the police agency complied with the procedures established for the processing of abandoned vehicles. And although Romulus Police Department was listed on the original petition and notice was sent, they have never appeared in this matter. There's not been any allegation made by any parties that the police department acted improperly. Additionally, that the private property owner requested removal of the vehicle and did comply with the provisions of MCL 257.252K or L, as indicated by Ms. Walsh's testimony that she received a call from Best Asphalt asking that these vehicles be, the vehicles that are subject to today's proceedings, be removed from the property. That the towing and storage, daily storage fees were reasonable, as indicated by Mr. Papazian when questioned by Mr. Austin, although Mr. Papazian indicated that he thought the fees were excessive. He had nothing with him and no testimony to support that allegation. And Mr. Austin's questioning of Ms. Welch supports the position that those fees, towing fees and daily storage fees, were reasonable and in accordance with local standards and other fees. That the towing company did comply with the procedures established for the proper removal and reporting of the abandoned vehicles. The court will deny the petitioner's petition in its entirety. Additionally, this court will award attorney fees in favor of Mr. Austin and against Mr. Papazian solely as the owner in the amount of $1,500. Mr. Austin requested 6 hours at $250 per hour, but the court will note that there has been a representative for J&M Towing present at all of the previous hearings. Mr. Austin has filed documents that supports the position of his clients acting properly given the wording of the statute. So attorney fees from petitioner owner to J&M Towing, Mr. Austin, finding that the police department, the private property owner, and the towing company comply with the applicable statute and the denial of the petition in its entirety. Is that clear to you, Mr. Austin?
It is. I took really good notes, Your Honor. I will run it by Mr. Nykel and Mr. DePietro prior to filing it. And if we don't get an agreement, we'll do it under the 7-day, but I will strive for an agreement on the language.
Is there anything else, Mr. Austin?
Nothing further, Your Honor.
Anything else, Mr. DePietro?
I think he said no, Judge. And I'll say no, Judge.
Damn, I keep.
Thank you.
No, Your Honor.
Thank you. That concludes this matter. I'll await receipt of the order either by agreement or by 7-day. That concludes this matter, and that concludes this court's docket for the day. Enjoy the rest of your afternoon, gentlemen.
Thank you, Your Honor. Thank you for taking the time to learn those statutes. Appreciate it.
You're welcome.